Okay, where, I'm trying to find a,
Mr. Chair, you have a quorum.
okay, thank you. Before we get started with the docket, Senator McDonovan's bill 1252 is going to go by for the day. Senator McDougal's bill 896 is going to go by for the day. Senator Morrissey has asked that his bill 1128 be stricken from the docket, and I'd ask for a motion on that. Okay, do we need a recorded vote on?
Yes, sir.
Okay, please open the roll.
Ayes 8, no 0.
Thank you, Mr. Clerk. Senator Peak's bill 1132 is going to be referred to the Rehab Committee. I'd ask for a motion on that.
So moved.
Second.
My,
Okay. We do need recorded votes on that, don't we?
11:30.
That's the Ed and Health? Okay, that's the Ed and Health. I apologize. Yeah. Okay, 1132 to Ed and Health.
Ayes 8, no 0.
Okay, Senator McPike's bill, Senate Bill 1140, is going to be re-referred to rehab. I'd ask for motion on that.
Second.
Okay. Oh, please open the roll. Senator
Ayes 8, no 0.
Lucas's bill 1214 is going to be referred to rehab. I'd ask for a motion on that.
So moved, Mr. Chairman.
Okay. Please.
Ayes 8, no 0.
Okay. Senator Obenshane's bill, Senate Bill 1228, is going to be re-referred to finance. Is that okay? Re-referred to finance, and I ask for a motion on that.
So moved.
Okay.
John.
Ayes 11, no 0.
Okay, my bill, Senate Bill 1298, is going to be re-referred to the Committee on Commerce and Labor. So I'd ask for a motion on that.
So moved, Mr. Chairman.
Thank you. Is there a second?
Second.
Okay, there's.
Ayes 10, no 0.
Okay, thank you. The following bills are going to be referred to the Civil Law Subcommittee. Senate Bill 931 from Senator Hashmi, Senate Bill 1033, and 1144, both from Senator McPike. That's all that's going to be referred to the Civil Law Subcommittee. So the first one we'll take up is Senator Reeves. Is he here?
Thank you, Mr. Chairman.
And I see three bills. Did you want one of those bills to go out for the day?
I did. The lieutenant from the state police to talk about the Rat Back program is the subject matter expert, and he had an appointment with the doctor that he wasn't anticipating, and he had to go take it today.
Okay, and is that Bill 1183?
It is, yes, sir.
Okay, so 1183 is by for the day without objection. So you've got 1200 and 1204.
Thank you, Mr. Chairman. Senate Bill 1200 is a bill this committee is very familiar with. I brought this bill before. We did pass this bill out, but in full transparency, I know there was some discussion about mandatory minimums, whether or not we do those again. I'm bringing this bill on behalf of several policing organizations that have had dogs injured and the line of duty and the replacement of those dogs, and they are requesting that we bring this bill back. And this is the one that said if you injure or maim or hurt a police animal in the performance of their duties, there'd be an enhanced penalty.
I apologize, Senator Reeves. This is a bill that says if you do injury to a canine, you've got mandatory minimum period of incarceration.
Yes, sir.
So-
We've heard it before.
It's a bill we have seen before. Okay, thank you, ma'am. Do any of the members have questions? Any of the members have questions? Will we operate, are there members of the public that want to speak on this bill?
If any Zoom participants would like to speak on this bill, please raise your hand electronically.
Mr. Chairman, this is only willful and intentional acts.
It is, Senator Oglesby.
Thank you.
All right, I have a question.
Senator Peterson.
Okay, and we have gone with the struggle about assault against a police officer and that being a mandatory minimum. Does this track the assault against a police officer? So now assaulting a police dog is the same as assaulting a police officer? Is that basically what this is?
It wouldn't be the same level, but it's tracking that level.
Okay, but they both have mandatory minimums of 6
They do.
months. Okay.
Well, and I apologize, was there anybody in the Zoom world that wanted to speak?
There are no speakers, Mr. Chairman.
Well, the committee operates on motion.
Move to pass it by indefinitely.
Is there a second? Okay, the substitute motion has precedence. The motion is to pass by indefinitely. Any discussion? Call the roll.
Let's do it.
Ayes 8, noes 5.
Okay, the bill's passed by. Your next bill is 1204, Senator.
Thank you, Mr. Chairman, members of the committee. Bringing this bill to try to rectify some of the things that have been happening with regard to some of the things we are seeing in schools to kind of help parents and everybody get on the same page of what they try to determine to be obscene. And so there's some very finite definitions of some of that as it relates back to obscene materials and books and those sort of things. And so the italicized parts of the bill I can read through, but I don't know, many of you all probably, like my office, have heard of books coming up in school boards and what those books say and all those sort of things. And I've been asked to try to clarify some of those definitions. So I worked with legal counsel to try to see if we can kind of narrow those down a little bit, but still within kind of what the Constitution holds true and those sort of things. So,
Senator, I'm wondering, Potter Stewart years ago in his Supreme Court opinion said that he didn't know how to define it.
You
but
know
he
when
knew-
you see
knew
it.
when he saw it.
Right.
So what impact is your language change having on the current state of constitutional law?
Well, I think if you look at number 4, italicized number 4 under B, such material performs, depicts, or describes one patently offensive representations or descriptions of ultimate sexual acts, normal or perverted, actual or simulated, including sexual intercourse, sodomy, sexual bestiality, or patently offensive representations or descriptions of masturbation, excoriatory functions, sadism, masochism, lewd exhibition of, and it goes on and on and on.
Yeah, not fun to say any of that.
Yeah.
Mr. Chairman.
Senator Edwards.
And Senator, you're aware that this does have First Amendment implications, without a doubt.
Mr. Chairman, I do understand those aspects of that, but I also understand that we have a lot of pissed off parents that are tired of having their kids come home with books that they didn't approve. And I think we owe it to our teachers and administrators in schools also to try to set some guidelines. And I think that's been part of the problem and part of the litigation that you've seen so far. I mean, you have a member on this court committee that's defending a father for the same thing, something that happened, separate incident, but they still had some of the things that happened within some of their books in their library. I know in my county, in Spotsylvania County, we've had those issues. I know in a few other jurisdictions within my Senate district, I've had to deal with these issues. So I'm really trying, and look, in full transparency, Mr. Chairman, you all are pretty smart attorneys in here. I'm asking for help. If there's something that we can narrowly define to get something going, I'm happy to pass it by and work with anybody on this committee to try to give these parents and administrators some guidance on how to proceed on these things. Or we're going to continue, all of us are going to have to continue with these what we're dealing with.
Mr. Chairman?
Senator
Yeah,
Edwards.
wouldn't you agree, though, that parents can be parents and explain things to their children? That's a better way to do it than just banning something.
Mr. Chairman, I would agree with you, but part of that is transparency with what their kids are coming home with. And then how do they have a formalized process to deal with that? Not every school district is the same, not all the way they treat parents is the same. And so I think if we can kind of help them along that path.
But, Mr. Chairman, the problem
Senator
is,
Edwards.
what you're getting to is basically banning books. You're not in favor of banning books, are you?
No, Mr. Chairman, that's words in your mouth, not in my mouth. I would totally disagree with you. What I'm trying to do is get to a definition of obscenity that we can all kind of live with, not that just if we see it, because everybody who just sees it or reads it has a different, maybe their faith is different than yours and mine, and maybe they don't agree with the same things that you agree, and that's where I'm trying to get to, Mr. Chairman.
Mr. Chairman, the problem I'm
Senator
having,
Edwards.
yeah, I think many of us are having, how do you compare, how do you not infringe, at least potentially, on First Amendment issues, free speech and all the rest? I mean, that's the problem. You start getting into it and you can't do this, you can't do that, then you get into First Amendment serious issues. That's the problem I'm having with the bill.
Senator McClellan.
Thank you, Mr. Chair. If the problem is books in school, the governor has already signed a bill that provides parents with, they have to be notified, given a copy of a book, given the option to require an alternative in the class setting. What this bill does is define obscenity for purposes of the criminal code. And which will open up a whole can of worms and have a whole lot of unintended consequences. And quite frankly, there are portions of the Bible, particularly the Old Testament, that could be found under this definition obscene. I don't think that's your intention. But if the problem you're trying to solve is how do we allow parents to review and object to books and materials that are in schools, we already have a process for that. And there's a separate code section and a whole separate committee to deal with that. I think we need to be very careful in changing the definition of obscenity for purposes of criminal statutes that criminalize certain behavior that can be seen as obscene. And I think this goes too far.
Senator Peterson, I see your name up here.
Yeah. Just to speak briefly to it, and I think I'll echo some of the comments that already happened. This does seem like it's a criminal definition. It's in 18.2, so it is. As it pertains to school libraries, one of the reasons I ran for state senate is so I didn't have to run for school board. Because to be honest, I got no interest in getting into that. And I think those people are crazy, God bless them. But we have a whole elected body that is elected to kind of make these decisions. It will be different county by county, community by community. I don't want to get into that. And I just feel like, there's a lot of case law on what's obscene, what's not obscene. We do have a definition in our code right now. I'd be inclined to not mess with it.
Yeah, Mr. Chairman?
Senator Edwards.
Yeah, follow up, Senator Reeves, I don't know if you studied the Bible. Actually, I spent a whole year in seminary, Union Theological Seminary, and one of the studies I had was, they kicked me out to go to law school. I studied the two semesters of the Old Testament. I can point to you some pretty bad things in the Old Testament. If you really want to protect children from hearing some of this stuff, I can tell you in Abraham and Sarah and then his concubine, there's some language in there could be offensive. And the other Song of Solomon, have you ever read the Song of Solomon?
Mr. Chairman, I haven't, I'm not a theologian by any stretch, but I do read the Bible, and I'm pretty good at what I do read, whether it be the Old Testament or New Testament. I'm an ordained deacon, and I'd be happy to work through those and help you through some of that passages if you'd like to.
You'd have to get some scissors to cut out some of the stuff in the Bible, even, seriously. But this is a problem with getting into this whole thing.
Are there other members that have questions, or
Yeah, there's some priests out there.
are there members of the public, whether they're in the room or in Zoom, who would like to speak on this bill?
Zoom participants who would like to speak on this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
But then the committee operates by motion.
I accept the motion to pass it by indefinitely.
Okay, substitute motion takes precedence. Please open the roll.
Ayes 8, noes 5.
Okay, thank you, Senator.
Thank you, Mr. Chairman, for working me in. Really appreciate it.
Next is Senator Cosgrove.
Good afternoon, Mr. Chairman, and well, thank you for your time. Mr. Chairman, I have 3 bills before your committee today. The first one I'd like you to consider is Senate Bill 857. This bill basically provides that any person who willfully and without authorization obtains, uses, or endeavors to obtain one of the trade secrets as defined in the bill, with the intent to either temporarily or permanently deprive or withhold from others the benefits of this, would be guilty of a Class 6 felony. Corporate espionage from foreign governments is a leading national security and economic threat. The FBI Director Wray stated in his the FBI opens a foreign government corporate espionage investigation every 12 hours. So, Mr. Chairman, basically Florida has already passed a bill that would have enhanced penalties for those who would take trade secrets to help other businesses outside of the United States. And I hope it'll be the pleasure of the committee to consider.
So there's already a civil action for
Right.
Intellectual property claims. You make a criminal action instead. And-
Yes, Mr. Chairman, and let me tell you why. Basically, the civil action is fine, but when it comes to corporate espionage, that can be a cost of doing business. This has a little more teeth. And certainly, we all know that we have a real problem in the United States with espionage.
Are there members of the committee that have questions? Senator Peterson.
Okay, yeah, my alarm bells just went off.
Okay.
And here's the reason why. There is a civil cause of action for trade secrets, and you typically, if you prove it, you get treble damages, which you don't have in here. And the reason why you get treble damages is oftentimes it's just not worth pursuing a lawsuit like that because it's a tremendous amount of work.
Right.
If you're just going to get the compensatory damages. And so this would need, in my opinion, to be married up to what we have, what UTSA, Uniform Trade Secrets Act, which I've hit some pretty big cases on that, so I know a little bit about it. Before we move this bill forward, we got to make sure these definitions match up and the remedies match up. So I don't know how to go about doing that. I mean no harm to the bill, but I do not want to lose our remedies under the UTSA.
Are you asking for the bill to go by for the day and try to?
I think we need to have council match this up and either incorporate the Uniform Trade Secrets Act or just make sure that the provisions are consistent. Steve, that's a
Chair.
project you need.
I see his eyes rolling back in his head.
Senator
Mr.
McClellan.
Chair, Mr. Chair, I think there's a broader policy question we need to answer before we get to that, and that is whether you want to make, stealing trade secrets a felony where someone loses the right to vote and in many cases will never get another job and has all sorts of other impacts. And to me, criminal penalties should be reserved for when there is a public danger, and simply misappropriating trade secrets in and of itself does not rise to that level. I think if the idea is you want to enhance penalties, then you can enhance the civil penalties, but I'm not sure that it rises to the level of putting someone in prison and having them forfeit their right to vote and all the other things that come with the Scarlet F.
That's a
Senator,
fair
I'd
point.
ask you, other than Florida,
That's a
are
good
there
point.
other states that have done this at some point?
Not that I know of, Mr. Chairman, but I will, if I may answer Senator McClellan's question there, or not question, statement. Basically, this is harmful. The FBI wouldn't be opening an investigation every 12 hours if there wasn't criminal intent.
Mr. Chair, harmful to public safety, putting someone's life in danger. And as someone who works in corporate America, I understand the impact that corporate espionage can have. But I don't think that it rises to the level of a felony as outlined in your bill. I think the civil penalties are sufficient. And if you disagree, if we want to enhance penalties, then we can enhance civil penalties. But I do not think this rises to the level of a felony.
I'm sorry to hear
Senator
that.
Obenshain has a question.
So, Senator Cosgrove, I'm not sure whether you are familiar with Section 18.2-499 and 500, the conspiracy to injure another in their reputation, trade, business, or profession, which does provide a criminal penalty even when there is no financial loss that can be quantified. Do you feel that this is a more serious problem than even some of those conspiracies to injure another in their trade and business, which we've already criminalized?
Mr. Chairman, if I might answer. Senator Obenshain, yes, because basically we have some of the largest defense contractors, in fact, all the largest defense contractors have headquarters in the Commonwealth of Virginia. That's where these trade secrets are gleaned. This is where they're stolen. This is where they're sent to other governments to harm Americans.
So, Mr. Chairman, for the
Senator
question,
Obenshain.
so we already put people in prison for stealing $1,000 worth of property, grand larceny. So are some of these trade secrets that this would, for which this would impose criminal penalties for stealing, worth maybe more than $1,000?
Mr. Chairman, I'd answer the gentleman, they can be worth hundreds of millions of dollars.
So,
Senator Obenshain.
So, Mr. Chairman, I would say I take a very different view from that of my friend from the city of Richmond. I think that all too often in domestic commerce and international commerce, we are given a pass or a slap on the wrist to corporate espionage in which national secrets, corporate, the jewels of the crown jewels of the company are stolen. This is not just something that we ought to allow Senator Peterson and I to file a civil lawsuit and hopefully reach some compromise. If somebody is destroying a business by stealing the keys to the kingdom, they ought to go to prison. Certainly, they deserve as much of a prison term as somebody who goes in and steals $1,000 worth of property from Best Buy.
Mr. Chairman?
Senator Edwards.
Anybody who deals with China, it's my understanding, if you deal with China, you're giving them your trade secrets.
Only if you're on TikTok, I guess.
Huh?
Yeah. Only if you're on TikTok.
Well, no,
No, I'm
it's not
kidding.
more
Yeah.
than TikTok. And so you want to charge in this country the Chinese? That's what would be the way I assume it would happen, because we know we're losing all sorts of trade secrets, and in order to deal with China, as I understand it, they require you to give them all your trade secrets. That's my understanding. I may be wrong, but I don't think so.
Well, Mr. Chairman, I'd say there's a difference between having a contractual requirement to provide trade information. It wouldn't be secrets. In this case, it would be intellectual property. This is dealing with theft of such, not just the contractual sharing of such.
Okay, are there additional questions? Are there members of the public who wish to speak to Senate Bill 857, either in the room or in the Zoom world?
Zoom participants who would like to speak on this bill, please raise your hand electronically. There are no speakers, Mr. Chairman.
Okay, then the committee operates by motion.
Report.
Okay.
Move to pass it by indefinitely.
Yeah, I'd move to pass this by bill by, if I could speak to the motion.
Okay, well, I think Senator Edwards made a motion, you're second.
I'll second his
You want to
motion.
speak to it?
Yes, and I think there is something here, Senator Cosgrove, in terms of foreign espionage, but the problem is, this is written so broadly, somebody could walk off with a customer list and suddenly be facing a felony. I mean, the trade secrets can be anything. I could have the formula for some type of recipe written on the back of an envelope, and that could be a trade secret, and I have it taped up in the kitchen, and there, you do have to take certain efforts to keep it secret. The bottom line is 99% of the time, this is a civil remedy. And I think we're talking about, oh, well, China, and there may be some time that somebody's using, is doing espionage. But this is written so broadly, I just think it's going to sweep up what is really civil conduct. And then the second part that for me as an attorney scares me is we're diluting the civil remedies. And, I'm not the only lawyer up here that's brought a trade secret case where, again, they're not worth bringing unless you can get extraordinary damages. So I'm going to second the motion to PBI.
Mr. Chairman, may I speak to that?
Senator
Mr. Chairman.
Obenshain.
Just, if I may, Senator Peterson makes an interesting point about stealing customer lists. Typically, that is these days procured by misappropriating it from a computer system, which I would point out to my friend and colleague is already a crime in the Commonwealth of Virginia under the Virginia Computer Crimes Act. We view stealing intellectual property as crime. What Senator Cosgrove has done is identified some high-value assets that are not protected under Virginia law. And if something happens within Virginia, between Virginians, and we've got an opportunity to have that prosecuted in the Commonwealth of Virginia, maybe it doesn't reach the level of interest for a federal prosecutor, but maybe it destroys a small business in, in rural Virginia, and maybe there is a prosecutor who's going to take that case. Maybe it doesn't reach the threshold that attracts the interest of high-dollar lawyers who are looking for hundreds of thousands of dollars in paydays, but that small business person who's been put out of business deserves a remedy. And if somebody has deliberately stolen the keys to the kingdom, they ought to pay the price.
Okay, Senator Morrissey.
Senator, did you ever have any discussion with the United States Attorney about this bill and whether or not they prosecute similar type bills? Similar type violations?
Mr. Chairman, I'd answer no, but I have talked with the Attorney General's Office of the Commonwealth of Virginia.
Okay. All right, let me just, quick comment.
Senator Morrissey.
This is the type of criminal offense, and I grant you, it is a criminal offense, that we would see prosecuted by the Eastern District of Virginia, the United States Attorney's Office. These type of crimes that have the type of components that you mentioned it to are the fertile territory for assistant United States attorneys and United States attorneys. That's the reason I asked you the question, if there had been that discussion. That's all. Thank you, Mr. Chairman.
Okay, Senator Stanley, did you have something?
Mr. Chairman,
Senator Edwards.
I can follow up on that a little bit. There's no question about it. Being a former United States attorney myself, the federal government has the authority under Racketeering, Influence, and Corrupt Organizations Act, RICO, the Mail Fraud Act, the Wire Fraud Act, Conspiracy Act, to do all sorts of things like this. So I don't see why we need to the extent that you're talking about, matters could well be criminal.
Well,
we need to put this in the Virginia Code.
Senator Stanley.
Now, thank you, Mr. Chairman. Now I do feel like I need to speak. When we talk about our U.S. Attorney's Office, we talk about criminal prosecutions. Those are usually involving a lot of trade secrets, large things. This provides that ability for the state to step in with prosecution by the federal government says, this is a little small. We go a little bigger, maybe a one-off trade secret violation. So quite frankly, I don't know why we wouldn't empower the Commonwealth of Virginia to protect its citizens from foreign agents. I don't know why we feel it necessary to let the fox into the hen house and wonder where all the eggs went. I think we need to get together here and say, when it comes to protecting the trade secrets, the intellectual property of persons who are citizens of the Commonwealth of Virginia who live here, I think that's what we owe as an obligation to do. So I think this bill addresses that, and it's in that gray area where that U.S. attorney will say, not the kind of trade secret that's sexy for us to get a lot of publicity on. We'll let this one go, or it's a one-time deal, or one person, one trade secret. We need to protect our Virginians. We are living in a world right now where we are getting screwed, and we need to stop it.
Okay, thank you, Senator Stanley. That's right. The substitute motion has precedence. That's a motion to PBI. I'd ask the clerk to open the roll.
Senator. Ayes 9, noes 5.
Okay. Ayes 9, no 5. The bill is PBI. You've got two more bills, Mr.
You're right one. Yes, sir. Mr. Chairman, I have Senate Bill 921 for you to consider. Mr. Chairman, the current law prohibits those convicted of serious sex offenses from loitering within 100 feet of a primary or secondary school or going within 100 feet of a school for the purpose of having contact with contact with a minor not within his custody. And these offenses include rape, forcible sodomy, abduction, contributing to delinquency of a child, and indecent liberties with the child. Now, what this bill does is it enhances the current protections by prohibiting those convicted for the following offenses from working or volunteering in a public or private primary or elementary school. And those would be rape, abduction, aiding prostitution, sodomy of a child or grandchild, incest of which a child or grandchild, rape, carnal knowledge of a 13 to 14-year-old, sodomy of a child, aggravated sexual prostitution, commercial sex trafficking, keeping or taking indecent liberties with a child, possession or production of child pornography, and hiring a minor to engage in a sex crime. Mr. Chairman, this just makes it very, very clear that people that have been convicted by a court of law of these particular, and in my opinion, heinous offenses, should not be allowed within our school systems to possibly prey on our most vulnerable of citizens.
Okay, I've got a note that if this bill reports, it has to go to the Finance Committee.
Okay.
Was there any situation that prompted this bill, or did this bill come from anywhere?
Mr. Chairman, I believe there's somebody here to speak to the bill.
Okay.
Zoom participants who would like to speak on this bill, please raise your hand electronically.
Good morning, Mr. Co-Chair, Mr. Chair. Good afternoon, rather. My name is Brandon Robleski from the AG's office. As the members may be aware, there was a school counselor in Fairfax County who had failed to re-register as a sex offender. He had a conviction for solicitation of a minor prostitute, which is not covered, which would be covered under this current bill. So this bill addresses that specific offense of soliciting a minor for prostitution, as well as all of the other offenses.
If he had registered as re-registered as a sex offender, he wouldn't have been allowed to be at the school, be employed at the school, would he?
That was certainly what we thought was going to happen. There was some kind of communication issue regarding his sex offender status between, I think it was Chesterfield and Fairfax. So that slipped through the cracks, but he has been charged with failure to register.
Mr. Chair.
Okay. Senator Morrissey's got a question.
Councilor, good afternoon.
Good afternoon, Senator.
If I understand your answer to the chair's question, the problem in that situation with the counselor was not that there wasn't a law on the books that prevented him from loitering within 100 feet of the school, but rather the breakdown in that example, because the chair asked you what the genesis of the bill was, is that the person didn't register on the SOR, correct?
That is correct, Senator, but also he had the outstanding conviction at the time that he was employed. So there was no trigger for that conviction of soliciting a prostitute that was a minor.
And educate me if it's necessary, but how could somebody who was on the SOR, as he hadn't re-registered. He was on the SOR. How can somebody on the SOR ever get to a position of counselor, much less teacher, much less coach, much less custodian?
Senator, I share your concerns. There was a communication issue with the status of that gentleman on the sex offender registry that was not adequately communicated between the authorities. I don't have a better answer than that. I apologize.
Mr. Chair.
Senator Peterson.
Sorry.
Senator Morrissey, were you finished?
I am done.
So I'm kind of in the same place that Morrissey is. We're hearing two different things. We're hearing, well, we got to expand the ever-expanding list of registered offenses, registrable offenses. But then we're saying, well, this person, the reason why we're doing it is because somebody fell through the cracks because they should have already been registered under the existing law. So I guess it's like, which one is it, folks?
So thank you for the question, Senator Peterson. There's two separate issues. There's the failure of this gentleman to re-register, which is not what we're addressing with this bill. There's the list of minor-related sex offenses that are currently not disqualifying for entering into school property and for having contact with minors that this bill intends to address.
Quick question. If you're finished.
I'm done.
Senator Morrison.
This is not an SOR bill, is it?
No, it is not.
This is not expanding SOR, is it?
No, it is not.
Which is a whole different kettle of worms.
Correct.
Because the chair and Senator Peterson are right. Ever since it first became a non-public registry, it has ever expanded, continually expanded. But that's not what this bill is.
No, this bill is simply expanding sex crimes against minors as disqualifying for contact with minors and entry on the school property.
Okay.
Okay. Thank you. There's somebody else that wants to, you're not in favor of the bill, is there anybody else in favor of the bill that would like to speak? Come on.
Mr. Chairman, committee members, I'm Mary DeVoy. The summary of the bill says it's for trafficking and prostitution, but there are actually 16 non-trafficking crimes on there. And some of those crimes could actually be committed by an 18 or a 19-year-old with a minor, or even a minor with a minor, of even a reasonable age gap of 2, 3, or 4 years. But because we say minors can't consent, that minor will be listed on our SOR for life. One day, these people will have children and grandchildren of their own, and perhaps they already do. Their kids need to be able to go to daycare. Expanding these 22 extra crimes will make it so that they cannot drop off or pick up their children from school, from daycare, from soccer practice, from drama rehearsals, both on and off school property. We're banishing parents, grandparents, siblings, and guardians for not just being on daycare, but from being within 100 feet of the daycare, the school, the park, and the school bus stop under the threat of a felony. The only option that will be left for the parent, grandparent, sibling, or the guardian is to petition the court. And before 2015, the court petition process was only expensive and lengthy. But since 2015, it became a publicly humiliating spectacle. Only a fraction will even petition for the right to be on the school property or attend a school event, and a minuscule amount of those people will be successful. Then there's the third part of this bill. It adds all Tier 1 and Tier 2 registrants to be prohibited from being on school property or any school-sponsored events. That includes school bus stops. This is under a Class 6 felony. Keep in mind, there are Tier 1s on our registry for a single misdemeanor. This is making Tier 1s and Tier 2s equal to Tier 3s. I understand the reasoning not to allow a registrant to work or volunteer on school property, but parents and guardians must be able to pick up their children from school when they are sick, and they should be able to attend their rehearsals and sports.
Okay, thank you, ma'am. Are there others who would like to speak on this bill?
Yeah, I have a question.
Well, Senator Peterson, I apologize, yes.
No, you don't apologize. I guess Mary brought up a great point in that we've had this issue with child pornography where children, send photos to each other in various undress, and oftentimes it could be a minor to another minor or a high school student to another high school student. And those types of offenses, if they're prosecuted and convicted, then get swept up into the statute. And that's my concern. I mean, we just, I just feel like this is very overbroad. And I'll give you a chance to respond.
Mr. Chairman, I'd say to Senator Peterson, I guess it's all in the eyes of the beholder what is overbroad. Do parents really want people with this type of offense record dealing closely with their children? I think most of the time that answer is going to be no.
I think that's correct, Senator Cosgrove. What I worry about is that if he had registered properly, then he wouldn't have been there in the first place.
I agree.
And this seems to me kind of to be an overreaction to that situation. We need to just enforce the law we've already got in the books. Are there other members of the committee that have questions, or if not, we operate by motion.
I move PB out of the bill.
Second.
You're just mean.
Are there other motions? So, somebody else wants to speak?
Yes, my name's Roscoe Eubanks. I'm from Charlotte County.
Come on
And
up.
it seems to me,
Come on up.
oh, I'm sorry. My name's Roscoe Eubanks. I'm just sitting in and listening. And it just sounds like you have a communications problem. And the people that aren't communicating, that needs to be fixed.
That does need to be fixed. We had a motion to pass by indefinitely that was seconded. We didn't have any other motions, so I'd ask the clerk to open the roll. Okay, strike the roll. We have a substitute motion to report and a second. Substitute motion takes precedence, so the motion is to report the bill. All in favor, vote aye.
Ayes 5, noes 9.
Okay, we'll return to the original motion. All in favor of PBI, vote aye.
Want to reverse?
Draw that motion.
No, that was the
I
motion
struck the
report.
roll. I struck the roll to PBI, and the vote was to report. It's defeated.
5-9, defeated, 5-9, defeated.
Just withdraw the motion. Next one.
You want
No, we're going back to the original motion.
The original motion was to
Original
PBI.
motion to pass it by indefinitely. Flip-flop. Motion PBI.
Ayes 9, noes 5.
Okay, Senator, you've got one more bill, Senate Bill 858.
Yes, Mr. Chairman. Senate Bill 858. This is actually brought forth because of a request by our Commonwealth's attorney. I've talked to several Commonwealth's attorneys. And it was either last year or the year before, we added the phrase mental illness into the code as one of the criteria for which courts could take into account the mental status of a person who committed a crime. The problem that we've had is we have created an incredibly monstrous loophole. People are walking out of court right and left because, well, I just wasn't feeling mentally right that day, and the code gives them an out with this. I think Mr. Green is here with Commonwealth's attorneys, maybe?
Any Zoom participants who would like to speak on this bill, please raise your hand electronically now.
If you would, sir. How you doing?
Good afternoon, Mr. Chairman. My name is Anton Bell. I'm with VACA, and we're here to to support this bill. And the reason we're supporting this bill is because it's overly broad. When you have an individual who is being found guilty of committing the offense, so we have individuals who have committed the offense, and the recourse is because of the mental health issue, or the charges are dismissed and they are released. There's no safeguard for public safety, such as what we have with NGRI. With NGRI, they can be sent to some type of facility so that we can somehow restore them and not have them pose any kind of danger or risk to our community. With this bill, literally someone can kill someone because of a mental health issue, be found not guilty, and that person can walk out of the courtroom after being released by the court, and they can, if they have a gun, they can receive that gun back. If there's no other issues that's keeping them from being able to hold a gun, they can get whatever property back, and they are put back into our community as if they never committed any type of act. And that is the problem. This bill does not balance public safety with the mental health issues that we have.
Mr. Chairman.
Senator Morrissey.
Okay. Do you realize, it's Mr. Bell,
Yes, correct.
Mr. Bell, that because somebody has a mental health issue, or one of the other matters was whether he's on the autism spectrum, that's not a pass. That's not a get out of jail free. It's just the ability to offer the evidence to the fact finder, be it a judge or jury. Do you understand that respectfully?
We understand that. However, when you offer that to the fact finder and the fact finder find them not guilty simply based on the mental health issue, that person is then returned to our community with absolutely no restraints or any type of accountability to keep them from being able to go right back out there and commit a similar offense and have blood on our hands.
Follow-up question. Follow-up question. Give me one case, one, where evidence of mental health defalcations came out at trial that was a nebulous or de minimis mental health issue. To quote my friend, Senator Cosgrove, I just wasn't feeling right that day, where a judge or a jury said, NG, go about, you're not guilty. One case.
Well, we have the safeguards in place with NGRI, so.
I'm not talking about not guilty by reason of insanity. When I said NG, I meant not guilty.
We don't need to debate. I mean, we don't
He's
need-
asking the questions. I'm just trying to answer them, sir.
Can you give me a case that had occurred where there was a de minimis case of mental health and the person was found not guilty?
I can't give you a personal case.
Thank you.
You're welcome.
Yes, sir. Are there others who would like to speak? Yes, sir.
Mr. Chairman, committee, my name is Brian Kelmar. I'm the Executive Director of Legal Reform for Intellectually and Developmentally Disabled, known as LRID, a national nonprofit located here in Richmond. Although this is a mental illness, this also impacts the autism community. 50% of autistic individuals aren't diagnosed till after they're age 5, and a lot of times even into their teenage years. My own son was undiagnosed until he was 16. 25% of this populations are not even diagnosed till later on in life, if they're even diagnosed at all. And what happens is people who are caught up in the criminal justice system are in or misdiagnosed with mental illness when actually they're autistic. And this situation, a lot of our autistic children are getting caught up in the criminal justice system, even though they're really autistic, but people interpret them as mentally ill. So we support the governor's bill of having the right help at the right time, and we oppose this bill. Thank you for your time.
Okay, thank you, sir. Yes, sir.
Good afternoon, Mr. Chairman. My name is Tyler Hart. I'm with Commonwealth Autism and also the Virginia Autism Advocacy Alliance. I echo Brian's sentiments around autism. There's often unintended consequences when you have something like this, and oftentimes with mental health, there are incidents where someone is caught up in it. It should be a valid defense in that case, and we oppose this bill.
Thank you, sir. Are there others in the public or in the Zoom world that wish to speak?
Yes, we have a few speakers on Zoom, Mr. Chairman. Jude Harrison, you may unmute and speak, and Teresa Champion will be going next.
Hi, I'm Jude Harrison, Director of Communications for LRID, and we definitely oppose this bill. The opportunity should be presented for a person to give their reasons for, however their mental health or their developmental disability showed up. So this bill would not give them that opportunity. Thank you.
Teresa, you may unmute and speak, and then Tanya is going to go next.
Thank you. Good afternoon. I'm Teresa Champion with the Virginia Autism Project and also with the Virginia Autism Advocacy Alliance. As we know, supports for mental illness are increasing, and this is a key evidence element of that reform. Please vote no on Senate Bill 858. Mental illness is a health condition, and evidence of any health condition, if it has a direct and substantial relationship to the conduct that's determined to be criminal, is relevant to the judge or jury for them to consider. Evidence of mental illness can explain the conduct, and mental illness can cause the behavior. Please vote no on Senate Bill 858. Thank you.
Okay, thank you, ma'am. Are there others? There's one.
Yes, Tanya, you may unmute and speak.
Okay, thank you. Tanya Milling, Executive Director at the ARC of Virginia. Yes, too often people with intellectual and developmental disabilities and mental health conditions have been trapped in the system due to guidelines that previously didn't recognize the impact of those conditions on the person. So we were happy in 2021 when we passed law of allowing evidence of disability or conditions of mental health thus ensuring that all defendants are provided every opportunity for fairness and justice in the court system. We ask you to preserve these protections and oppose this bill. Thank you.
Thank you, ma'am.
There are no more speakers on Zoom, Mr.
We've got
Chairman.
one more in the room that wants to speak.
Sorry about that. Please.
Good afternoon, Mr. Chair. Ashley Shapiro, the Vice Chair of Justice Board, Virginia, and we strongly oppose this bill. Just to clarify some of the misstatements that have been made, Mr. Bell claimed that if anyone was using the statute, they would be found not guilty on murder. That is not how the statute works. As Senator Morrissey mentioned, all this statute does is allow evidence to mitigate intent. If this was actually used in a murder case, most likely it would be still a manslaughter conviction. Again, the misstatements of walking out of court left and right, there's not a single example where that's actually happened. Conversely, I have used this statute in my practice. It's incredibly difficult. This statute was expertly crafted by this body, advocates, mental health advocates, and attorneys who actually understand how these rules of evidence work. I would point this committee to the specific language that has to significantly impair the judgment or capacity. It is not just any mental health diagnosis. It is not just someone who doesn't feel well that day. It has to be someone with a recognized diagnosis who also had that diagnosis directly impact their behavior in the case before them. It is an expertly crafted bill that should be preserved, and we adamantly oppose this bill.
Mr. Chairman, I have a question. Who are you with?
Senator Edwards had,
lady, ma'am.
Senator Edwards has a question. She's from Justice Ford, she said.
I didn't hear that very clearly. Who are you with?
From Justice Ford, yes, Your Honor.
Okay, thank you.
You know, what I will say, this was a bill in 2021 from Senator McClellan and Delegate Bourne in the House of Delegates. And they directed part of it to be looked at by the Behavioral Health Commission. And what this has resulted, I think, in 22 or 23 people statewide, is that right, Sarah? That have been found not guilty. And one problem we did identify, and there's some other bills, is that at the end of the trial process, when they're not found not guilty and they're really not subject to a TDO anymore, there's no way to force them, there's no way to get them into services, to mandate them into services. So, no, that's not what this bill says. So we will have about 3 bills, I think, aimed at doing that might be viewed by other committees, might be viewed by this committee, I don't know.
Mr. Chairman.
Senator Obenshain.
You know, I've served on this committee for 19 years, and I guess it's my 20th year. And I really usually appreciate the manner in which bills are discussed and debated. And I would hope that we would adhere to, high standards and not engage in ad hominem attacks. I think Senator Cosgrove is perfectly capable of understanding what he's doing. I do not believe that Senator Cosgrove or any of the people who have testified have misrepresented anything. I understand that people may have a difference of opinion, but I do not appreciate having colleagues or witnesses maligned or suggesting that they have been dishonest or that they lack the enlightenment that some witnesses so clearly have. So, Senator Cosgrove, I appreciate you bringing this bill. I understand that people have different opinions about it, and I would hope that it is just that.
Thank you, Mr. Chairman.
And I certainly hope I didn't malign you or...
Absolutely not. Mr. Chairman, can I just make one more comment before you take action on this?
Yes, sir.
I've been in the General Assembly 22 years. I've never served a day in courts of justice, and I'm really, really happy about that. When I have bills that are not going before courts, I figure that I'm having a really great session. So I did not bring this up. I didn't think this up by myself. It was brought to me by a couple of Commonwealth's attorneys. So there's got to be at least one case, where this had happened.
Mr. Chair.
Senator Morrissey.
John, Senator Cosgrove, I also don't think that you would bring a bill that you didn't feel in your heart was appropriate. But let me just explain the genesis of this. I was a co-patron on Senate Bill 1315. And the problem was this, that under the former procedure, if an individual had a mental health defalcation, he or she could not bring it up during the guilt or innocence phase. The only time they could do it is if it was not guilty by reason of insanity. So the spectrum went from here to here. And if you weren't pleading not guilty by reason of insanity, you couldn't get it in. So the individual that was walking down Chamberlain Avenue, and there was a helicopter, a Martian ship hovering above him and telling him to go into this building. That was his defense, and he had significant mental health issues, could not bring it up to show the fact finder that he didn't have the requisite mens rea. As one judge once said to me, you can bring it up at sentencing, Mr. Morrissey. And my response was, I'd like not to get there. So what this bill did last year, Mr. Chair, was Senator McClellan and I and other stakeholders said, let's allow an individual with a mental health deficit to get that evidence in during the guilt or innocence phase. We also allowed people that were on the autism spectrum disorder to get it in. And there was a reason for that, because there was an actual case where a young man who had never gotten any criminal trouble before was on the autism spectrum, was leaving a parking lot. There was a collision, and there were sirens and loud noises, and he did not respond well to loud noises. So his car was hit. So he drove up and then came back, but he was charged with leaving the scene of an accident. And his attorney was prevented from telling the fact finder, listen, he has autism, he's on the spectrum, and loud noises and sirens bother him. So all this bill did was allow evidence of mental health deficits or being on the spectrum to come in during the guilt or innocence phase. But Senator, I can assure you it is no pass or get out of jail free. Thank you, Mr. Chairman.
Mr.
And
Chairman,
at appropriate time, I'll have a motion.
If I might just basically respond to some of the autism questions. If you look on line 25 through 26, autism in the spectrum, basically as diagnosed in the Diagnostic and Statistical Manual of Mental Disorders of the American Psychiatric Association, is there and it's untouched. Okay? I guess the biggest problem that I see as a non-lawyer, I'm always asked in courts, well, how do you define this or how do you define that? Well, in this bill, it just says mental illness, period. And I think it's being abused. So thank you, Mr. Chairman, for your time.
Okay, thank you very much. Are there motions, or that's how the committee operates?
I have a motion, Mr. Chair.
Senator Morrison.
Respectfully.
I'd like to swear out a warrant over here. That's a Southwest Virginia. Senator Morrissey.
Mr. Chair, respectfully, I move to PBI the bill.
Second.
Substitute motion.
Substitute motion to report. Do we have a second? Second. Okay, substitute motion takes precedence to report. So that's the motion. Please open the roll. Vote aye, vote to report the bill.
Ayes 5, noes 9.
Okay, so we go back to the original motion, which was to PBI, so a vote aye on this motion is to PBI the bill. Please open the roll.
Thank you, Mr. Chairman, and your
Ayes
time,
9,
for your
noes
time.
5.
Members of the
Thank you,
committee,
sir.
thank you.
Okay, next is Senator DeSteph. And I apologize, I never get this exactly right. Is it DeSteph or DeSteph?
It doesn't matter.
DeSteph.
As long as you call me up here and I'm not here till midnight, I'm good. So, Mr. Chair, members of the committee, let me draw your attention to Senate Bill 1004. The bill permits law enforcement officers from disclosing their home address, telephone number, or any other personal information should they choose while testifying in open court unless it is relevant to the case at hand. And we are all aware of our law enforcement officers across the country being under attack for different reasons. This is an opportunity to keep their private life a little more private. When I lived up in Fairfax, when I was still in the military, one of my neighbors was a police officer, and had one or two incidents where, on the record, he had to provide his personal information, and the individuals came to visit his house. So it wasn't a very kind thing.
And certainly, I don't have any objection to what you're trying to do, but I just was wondering when a law enforcement officer's home address would ever be relevant in a case. Steve, Mr. Benjamin?
No, never.
So it means.
I can't imagine somebody being permitted to ask that question. But if it happened, it happened.
Mr. Chair, members of the committee, yes, and that's one of the reasons the bill is coming forward in front of us today.
Oh, yeah, I guess
Senator Edwards.
The question I'm having is, why is it even necessary? I've never seen it come up either, that they ask, where do you live, officer? And I'm sure the prosecution would object and the judge would sustain the objection. Why is it even relevant? I mean, has it ever really come up? I've never seen it come up.
Mr. Chair, Senator Edwards, I know for a fact that it was put out there a couple of times because I lived in Fairfax maybe 25 years ago, and my neighbor had some visitors. But more recently, the patron who asked me to carry this bill has brought it up and said this is starting to become an issue. I don't know if it was because the press provided that information, or if in fact under some kind of court case, the officer had to bring that up. I'm sure with the Commonwealth Attorney, the AG's office, and all the rest of the folks here, I'm sure they could probably give you an example or two to clarify this a little better.
I would love to hear an example. I can't imagine this ever being relevant in a trial.
And
Unless
as one
there's a crime
partic-
that occurs at a police officer's home.
Exactly. Yeah, Mr. Chairman, I was just going to, speaking to the bill, I guess. There's lots of different evidentiary rulings we could place in the code of Virginia, but I'm not really clear. There's all kinds of things that are only relevant under certain circumstances. The code would be 10 miles long if we passed bills like this every day. And so I'm just not really clear what the need for this is. And if there's a judge who made an officer answer a question that wasn't relevant, that's an issue for the Court of Appeals or whatever. It's not an issue. I don't see why we need a statute for it. So I'm just curious why this is an issue.
I will reach out and get the assistance from a couple of folks here who can, I believe, help with the Sheriff's Association and I believe the AG's office, and I'm not sure who you're with.
May I approach?
Sure.
Any other participants who would like to speak
My
on
name's
this bill,
Justin
please raise
Griffith.
your hand.
I work at the Commonwealth Attorney's Office in Pulaski County. I had no intentions of speaking on this bill. You guys did ask some questions about police officers' address. Senator Deeds is an off-duty police officer. He's at 123 Main Street watching Wheel of Fortune. He hears gunshots. He leaves his house. He gets there. He says, it took me 6 minutes to get there. Oh, it did? Yeah. Well, where do you live? So that's where you live, and that's how long it took you to
Why
get
would
there.
where do you live? Would that ever be relevant? I know you're circuit court judge here in Pulaski County, and I think he's got a pretty good idea how to.
What if there was an alibi,
Who's
though?
evidence?
I wasn't there. It took him longer. It wasn't me. It took Senator Deeds so long to get to the scene because of where he lives. It couldn't have been me. It couldn't have been the gunshots that he heard. So it does come up when police officers respond to calls from their house. It does come up.
Mr. Chairman, how about a crime that takes place in the neighborhood of the police officer? I mean, it could certainly be relevant under those circumstances.
I believe with the Sheriff's Association, we may have a couple more actual examples.
If I may, Elizabeth Hobbs with the Virginia Sheriff's Association. It is accurate that this is a restatement of the law, that only relevant evidence is admissible. So this is not a new premise in that vein, but under an ordinary trial circumstance, you're relying on, in a criminal case, the Commonwealth's attorney, assistant Commonwealth's attorney, to make an objection. And this bill gives some ground for an officer, a law enforcement officer, who is testifying as a witness or as a victim in a case, a citizen witness who's may not testifying in their professional capacity, to have a leg to stand on to say, I do not want to share this evidence.
Mr. Chair.
Do you have real world examples of of this sort of evidence coming
I
in?
don't. In my time as a prosecutor, I would have objected to that. But I do know that not every time is a case handled by a prosecutor. Certainly, we have general district courts where a citizen or a police officer even may be testifying without a prosecutor participating in the case. So there would be no litigator on that side to make that objection for them.
And so what, you've got no prosecutor, but you still have a judge who presumably knows the rules of evidence.
Yes.
Senator Peterson.
Yeah, I mean, look, guys, there's either relevant evidence or irrelevant evidence. And if it's irrelevant evidence and it's prejudicial to you, me, the police officer, Senator Suravel, I mean, there's all kinds of people. I testify in cases too. People could ask my home address. Maybe someone comes and harasses me. The bottom line is trial judges make these calls all the time. We don't need to put this in the code. Okay, if we put every single hypothetical situation in the code, we could fill up this whole wall with black books. So we don't need this in the code.
Mr. Chairman.
Don't you agree? Thank you.
I don't agree respectfully. We're supporting the bill to give law enforcement officers support and protection of their private information. Thank you.
Mr. Chairman, and those who are speaking on the bill, that you can say this about, let's say, any witness, a mafia witness, a good example. They don't want to tell anybody where they live. That's why the federal government has a witness protection program. But there are cases that come up, I'm sure, where any witness says, I don't want anybody to know where I live. That happens. It's not just police officers. It could happen, but again, we have in the code, if it's relevant, it should come in. If it's not relevant, it wouldn't come in anyway. So I think it's right that the judges can apply the rules of evidence if necessary.
Thank you, Mr. Chair. And Senators, I do have a personal example. When I was a prosecutor in Portsmouth, I prosecuted a case where a Portsmouth police officer and his wife took out warrants for stalking that were filed in the city of Portsmouth. This bill would actually prevent their personal information from being disclosed in the exact manner that I think the senator, the patron, is intending to protect against.
So the police officer was not just an investigator, or he was a complainant.
He and his wife complained of stalking against them. They were the complainants. They took out the warrant. So they were my victims at this case, and their personal information was all over these documents. I remember the officer very well, actually.
Yeah.
So I do have a personal experience with that. I can inform the committee.
Mr. Chair.
Senator Morrissey.
Senator Steff, you realize that sometimes a judge may order evidence disclosed, but it is done in a manner that prevents it from being disseminated further. Were you aware of that? In other words, the judge may say, I'm going to give you this, Mr. Defense Attorney, I'll give it to you, Mr. Prosecutor. It is not to be shared, and it's not to be disclosed to any other parties. Wouldn't that possibility protect what you're trying to accomplish in this bill?
Mr. Chair, Senator Morrissey, yes, in essence, it really would. But do we believe that every judge believes the exact same thing? I think the answer to that's no.
Okay. All right.
It says that they can refuse relative to a criminal investigation or in a proceeding preliminary to a criminal prosecution may refuse unless ordered by court to disclose. That's lines 15, 16, and that's lines 15, 16 of the bill. Okay, are there others in the public that would like to speak, or in the Zoom world?
There are no speakers on Zoom, Mr. Chairman.
Okay, do you want a minute or two to wrap it up, or do you just want us to?
Mr. Chair, I honestly believe that any protection we can give our law enforcement officers in a manner such as this to help protect them and their families, we should do. I don't think that a 19-line bill is going to expand our code section to cover the entire wall, but I do understand that every grain of sand makes a beach.
Okay, well then the committee operates by motion.
I move to PBI. Substitute motion.
Substitute motion.
PBI.
Is there's substitute motion takes precedence. We'll open the roll. A yes vote will be to PBI.
Ayes 9, noes 5.
bills, PBI. You've got another bill, Senator?
Mr. Chair, I've got a couple more. If you didn't like that one, we'll see how you do with the next ones.
Okay.
Mr. Chair, the next one is Senate Bill 1288. It's also referred to as Bentley's Law. And what happens here is basically with the increased 22% of drunk driving or driving under the influence that we're seeing almost every year, we're seeing more and more parents and adults being killed and not coming home. What this bill does is says, in addition to the damages awarded pursuant to 801-52, this gives basically child support for any child who's left without a parent because of that accident or that incident where a drunk driver or someone driving under the influence were to eliminate the life of their parent. So this is, in my opinion, this is a great opportunity to take care of the victim that's of an unintended crime of when somebody drives drunk and kills somebody, and this allows the that individual who does that to take the responsibility and basically pay for the child's raising.
Senator Steph, there's a separate code section in Title 46.2 that deals with commercial drivers that have DUIs. That's not included in this. Was that intentional?
I don't believe that is included in here, and
Mr. Chair, I think that was just an oversight on drafting. I think that was probably should be included, but I think it was, there was a similar bill, and I think it was just unintentionally dropped.
Mr. Chair, I'd happy to accept that as a friendly amendment.
Okay, we might, if we get to that, yes. Senator
I
Morrison.
have a question, Mr. Chair.
Yes.
Mr. Chair, this is also supported by Mothers Against Drunk Drivers, and we've had 4 or 5 other groups call in support of this.
Senator Morrison.
Senator, let me just preface my comment that I agree with the spirit of what you're trying to do, to wit, that a child, an infant, is protected. But normally what happens is this, whether it's a boating accident or car accident, whether the cause is DUI or whatever, there's usually a follow-up civil suit. And that follow-up civil suit, it's going to be filed by the legal guardian or the next of kin, or what's that term?
Next friend.
Best friend or next friend. And they're going to sue for a lot more than just pay child support. They're going to sue for significant monetary damages. So I'm just trying to figure out, this seems to be a narrow carve that the person can petition for child support. Why not go for the whole? I mean, we already have, it's already covered somewhere else. It almost looks like a solution looking for a problem.
Mr. Chair, Senator Morrissey, I started this off with line 16 of the bill, and I'll reiterate that. In addition to the damages awarded pursuant to 8.0152 for the action of the death of wrongful act where the defendant, as a result of driving under the influence in violation of clause 2, 3, 4. But basically, this is in addition to those damages. So yes, is this a little stricter? Absolutely. Why? Power projection is a force deterrent. If we make the penalty stiff enough, maybe folks will have a second or third look at getting behind the wheel when they're under the influence.
Senator Surville.
Thank you, Mr. Chairman. I guess this will sort of be a question, but here's what I don't understand. Normally, damages are a function of what's foreseeable. And, you know, when a collision happens, whatever, you don't know whether or not what the situation is, the person who's hit, but there's a full foreseeability issue with this, number one. Number two, it seems to me that the child support might end up being an offset against any judgment you would recover that Senator Morrissey identified. Number three, it's not clear to me why we would say you pay child support if somebody dies by drunk driving instead of murder. which is worse, right? I mean, in addition to that, I would say that, like, riddle me this. I mean, suppose somebody there's an accident, drunk driving is the proximate cause, but the person isn't killed, they're just horribly hurt and can never work again. This parent is horribly hurt, can never work again, and they can't provide any support, whatever, for a child, but they don't pay child support for that, only if the person dies. I mean, from a policy point of view, I just don't understand how you square all these things together. It just seems to me, I think I read this was done in like Indiana or someplace. It's just not clear to me why this is a policy solution to a specific problem. Maybe you could answer that or respond to it.
I think Tennessee. So Bentley's Law was enacted in Tennessee. I wanted to make sure I qualify the appropriate state. But yes, this specifically is for the loss of life of that parent or guardian. Bentley's Law did not specifically go after those who are just severely injured. We copied this pretty much similar to what they did in Tennessee. If you think that it would be better expanding it to injury or grave injury or lifelong injury or anything like that, I'm happy to take that as a friendly amendment, Mr. Chair and Senator Servell.
Senator Obenstein.
Bill, I understand what you want to do, and and I don't know Tennessee law, but I will tell you that in Virginia, for wrongful death, our model jury instructions include damages for any reasonably expected loss of services, protection, care, and assistance which the decedent provided to the beneficiaries. So in my experience, and I've been a defense lawyer and a plaintiff's lawyer, and that is always part of what is presented in a wrongful death case. And moreover, if it is a case involving intoxication, those judgments are not dischargeable in bankruptcy. So, I think I appreciate what you're trying to do, but I think in Virginia, we've got that angle pretty well covered. At least that's my impression.
Yeah, Mr. Chairman, I was about ready to say the same thing. We already have, civil action for death by wrongful act, such as driving under the influence and so forth, and I don't see this adds anything.
What this does add, death by wrongful act, you're talking about in wrongful death, the insurance company's paying. This way, you're going to get that guy, the guilty party, to continue to pay until the child turns 18.
Yes, Mr. Chair, that's correct.
Or finishes high school. So that's in addition to the insurance.
I don't know that it would be an addition. It may be a set-off and get the insurance off the hook for it.
Yeah.
And harm the child and the family in the interim while the guy's in prison.
I get that. Are there those in the public that would like to speak to this bill?
If any Zoom participants would like to speak on this bill, please raise your hand electronically. There are no speakers on Zoom, Mr. Chairman.
Okay, the committee operates by motion.
I move we PBI the bill.
Second.
Okay, we've got a motion to PBI and a second. Open the roll, please. I apologize.
Ayes 14, no zero.
Mr. Chair, thank you. With that, I'll move on to the next wonderful bill, Senate Bill 1296. And, Mr. Chair, members of the committee, this bill basically, with what we've seen recently, we see a lot of people walking out of stores with just under $1,000 worth of merchandise, and a lot of the stores are not stopping or responding appropriately and just letting them walk out, and they're taking this as a hit to the bottom line. Then they're increasing prices. We're actually seeing this in grocery stores, and in some of the grocery stores, I believe in one of the food lines down in Hampton Roads, they have the highest theft of any food line in the country and have decided to close that store. And now we go back and say, well, we have a food desert in that area. So, Mr. Chair, members of the committee, what I've done is looked at rolling back the limit of larceny, petty larceny, from $1,000 back to $500. And there's a small financial impact on this, fiscal impact, and it's estimated that in 2029, so in 5 years, roughly $14 million would be the financial impact. And I believe if you extrapolate that out, I think in 2050, that would be closer to about $100 million financial impact. But that's the bill, because what we've seen at a lot of our retailers is folks just pulling a calculator out, adding it up, and if it's under $1,000, putting in their cart and walking out. A lot of stores are being told, don't stop them. It's not worth the risk of life to you. We'll call the police, and if they respond in time, great. If not, well, we've got their pictures. When it comes to our grocery stores, when people are walking out with a cart or two loaded up, they're being told basically the same thing. And in one of these stores, I've had a long conversation with the manager of the store, and their comments are, people are complaining about a food desert, but it's about to be a lot more dry because we're going to have to close up because we have more food leaving without being paid for than being paid for.
Okay, does everybody understand the bill? This bill goes back on some policy decisions we made a couple of years ago.
2020.
Yeah. Senator Morrissey.
Senator, at first when I read this bill, I was thinking this is going to address that situation which is sometimes referred to as a smash and grab. The individual, or sometimes they walk into not a grocery store, but a department store, and in what I would only describe as the most brazen move imaginable, takes a large television set and literally walks out, and the people are saying no, and they just look at them and keep going. Sometimes it's several people that do it, but it warrants some type of additional penalty because it's just the most audacious thing I've ever seen. But I'm not sure that this bill is the one to do it. So tell me why it is, because we felt that threshold had not been raised for, I think, may have been decades, and that it just wasn't, $500 wasn't commensurate with a grand larceny.
Mr. Chair, members of the committee, Senator Morrissey, at one of the Home Depots I go to, we've seen people go in and add up what they're putting into their cart. One of my friends works in that store. He said they'll use a calculator, add up what it is, and they will literally not go out the outdoor, they'll go out the indoor and just walk out. And the store employees are told, do not approach that individual, call the police. If they respond in time, great. If they don't, let them go. It's not worth somebody losing their life over. And I think that a lot of stuff we did back in 2020 changed their trajectory, and we're seeing in a lot of our cities, a lot of our counties, we're seeing our criminals get a lot more brazen. We're seeing crime go up substantially. And we'll have the mayor of one of our cities testifying with us on another bill that I'm bringing up, similar to what we rolled back in 2020, because of the crime levels increasing in Norfolk and their inability to be able to go after these individuals in such a manner. So, Mr. Chair, Senator Morrissey, I think this is a first step in that direction. Do I think it's the complete solution? No. But when, as an example, Norfolk is down a couple hundred officers, Virginia Beach is down over 150 officers, that it's harder for law enforcement to respond to situations like this. So we've got to take a first step to make a difference.
Senator Morris.
Brief follow-up question. Let's assume that I agree with everything that you said, and much of it I do. Why aren't we actually, though, throwing out the baby with the bathwater here? Because everything we accomplished by raising the threshold from 500 to 1,000 is now being negated because of this example that you give, which is, I agree, it's horrible. And the brazenness is beyond the pale. But aren't we also necessarily undoing all the good work that we previously did by raising the threshold?
Mr. Chair, Senator Morrissey, I think that when we look at the significant increase of and the amount of and instances of petty larceny, I'm not sure we accomplished what we were trying to do. I believe that we've seen more brazen, more increases to the point where we have a lot of not just grocery stores, but mom and pop stores and stores going out of business because of this. And on the other hand, I sit on a couple of committees where we listen to concerns about food deserts and stores closing down and not having access to various stores. This is one of the reasons that that is the case.
Sure, I think we understand the policy differences between where you are and where Senator Morrissey is. Are there people in the public that would like, Senator Peake, I apologize.
Thank you. Thank you, Mr. Chair. What am I needing to do here? Thank you. Listening to some of the conversations I did, Senator Steph, what you're trying to address doesn't seem to we amend this to address the smash and grab that's in Morrissey's
Mr. Chairman.
instead of the threshold, the multi-theft, or you go in and tandem, and I don't know what that would be if we had time to do.
Senator Servell wants, I think, do you want to interrupt what he's saying?
Yeah.
Do you mind being interrupted by Senator
I'm
Servell?
always happy to be interrupted by
Okay.
Senator Servell.
Thank you, Mr. Chairman. Speaking to the bill, I guess, so.
What?
No,
I think he was asking a question.
Well, I was about to give him an answer, which I think he'll like.
Okay.
Which is, I believe the Attorney General has a bill to deal with that situation, which he's working on with Senator Barker, which we're going to see later this session, which will address the whole smash and grab gang shoplifting problem, and I think that's coming. So I would ask you to wait for that.
Can I say something?
Senator Saslaw.
Senator to staff.
Can we take his by for the day and roll his in?
Oh.
If that addresses his problem, if he wants to do that?
Mr. Chair, Senator Obenstein, I'd be happy to do that.
Or is this a brochure bill?
Okay, do you still want to?
I mean, he wants to address the same issue, I think.
I was just going to say that back a few years ago, quite a few years ago, well, 25, came to my attention then when it was, the threshold was $200. A guy who had been in jail several times because of his temper, he was in a shopping center and he couldn't find a place to park. The guy who had a pickup truck apparently had taken up 2 spaces. And he got out of the car, his car, and he kicked a couple of dents in the door. And the cost of fixing it then, would be more now, but the cost of fixing it then was just under $1,000. Because he had been in jail a couple of times because of his temper, it was $900 worth of damage. The judge gave him 3 years in prison. So for $900 worth of damage, taxpayers had to shell out $90,000. Kindly explain the benefit of that.
Mr. Chair, Senator Sasla, I believe that's damage to property we're referring to in my bill, and the bill we're talking about with Senator Barker, petty larceny, which is a completely different section of code. But I do enjoy hearing your story, sir.
Okay, the bill's going by for the day. Before we get to the bill's going by for the day. Before we get to the next bill, I'm advised that I made a mistake in Senate Bill 1128. Senator Morrissey, my understanding was the bill was to be stricken. He wanted it to go by for the day. I've actually got a note that it's to be referred to rehab. So I would ask for motion that we reconsider the vote by which we struck the bill.
So moved.
Okay, do we need to record that vote? Then open the roll. I'll vote yes is a vote to reconsider the bill.
Yeah.
Then I would,
Senator Deeds? Ayes 15, no zero.
okay, then I would ask for a motion to refer the bill to rehab.
Mr. Chair, so moved.
Okay, is there a second?
Second.
Please open the roll. Okay,
Ayes 15, no zero.
next I have Senator Hashmi, then Senator Hackworth.
Thank you, Mr. Chair, and members of the committee. This is SB 929, and this bill seeks to address a problem that many states are trying to resolve, and basically it's the issue of the discrepancy that exists between federal immigration law and the one-year maximum sentence for Class A misdemeanors in so many of the states. So just as a background, federal immigration law allows for the deportation of a legal permanent resident, that is someone who holds a green card, or visa holders for the conviction of a crime of moral turpitude, which, as we know here in Virginia, is a sentence of 1 year or longer may be imposed. And because of our code, Class 1 misdemeanors are punishable by up to 12 months in jail, and that 12 months can mean for individuals who are green card holders or visa holders that they may then be deported. So this bill, this legislation is often called the 364 bill or 364 bill. If we take away just that 1 day from the sentencing, the basic sentencing guidelines of 1 year, that means that we have the capacity then to address the issue of the individual, but not automatically ensure that it falls under the federal immigration laws, which then can mean deportation. And so an individual doesn't even have to be convicted of the crime for a 12-month sentence, but just knowing that that is the allowable sentence for a judge, that can trigger the process for deportation. And so we've seen in Nevada, in Washington, New York, Colorado, and Utah, just in the last couple of years, that those states have moved to change the maximum penalty to 364 days rather than in code, say, 1 year. So it's that 1 day that's making a difference. And so this bill asks that we do the same in Virginia, change it from 1 year to 364
Does everybody
days.
understand what the bill does?
Yeah.
Okay, are there any questions?
I have some questions.
Okay, Senator Peterson.
And first of all, I think this is an excellent idea, but my concern is that by making a misdemeanor less than a year, first of all, does our Constitution define a misdemeanor versus a felony? And secondly, I mean, how would it be? I remember there was originally, I think the Gideon case said that if you can be confined for, and you can be imprisoned for a year or more, then you have a right to legal counsel. So I guess my question is, are there further ramifications of doing this such that a felony, a misdemeanor is now less than a year?
I'm interested in that. What are the ramifications with respect to court-appointed counsel?
I'm looking at Senator Benjamin over there. He's violently shaking his head.
No.
Okay. None.
A person who's subject to a 364-day penalty is still entitled to court-appointed counsel?
Yes.
Okay.
Yeah, oh, sure.
And is it defined in our Constitution, a felony or misdemeanor?
Mr. Chairman, Senator Peterson, I don't think it's a subject in the Constitution. I think it's defined exclusively within, I think it's Title 18.2.
Are there additional questions? Are there people in the public who would like to speak to this bill, either in the room or in the Zoom world?
Any Zoom participants who would like to speak on this bill, please raise your hand electronically.
Okay, in the room, we've got somebody. Well,
Mr. Chair, Christian Martinez, CASA Advocacy Specialist. We advocate for 10,000 Latino immigrant and working class Virginian members. We support this bill. It is one day that will impact many immigrant families, but one day that you can impact many lives. So we ask you that you please support this bill. Thank you.
Yes, ma'am.
Hi, Brianna Diaz with the ACLU of Virginia. We support the bill for the reasons shared. Thank you.
Thank you, ma'am. ACL. Okay, are there people that have another view? Are there people in the Zoom world?
Yes, there are. Dominique, you may unmute and go first, and then Freddie, you will go after.
Indicate. Greetings and thank you, Mr. Chair, members of the committee. Dominic Martin, New Virginia Majority. For the reasons stated, we also would support the bill.
Thank you very much. Who's next?
Mr. Chair, members of the committee, this is Freddie Mejia with the Commonwealth Institute, and we support SB 929. Thank you.
Okay, thank you very much. Who's next?
Becky, you may unmute and speak.
Hi, my name is Becky Wellison, and I'm a senior attorney with Legal Aid Justice Center, and I am here to voice our organization's strong support for SB 929 and to thank Senator Hashmi for introducing this at this session. We strongly support this because it would help address the vast disparate impact of various criminal sentences and prosecutions on the immigrant community in Virginia, and not only would it protect legal permanent residents and others who live in Virginia, but it would also provide really important and valuable protection to those seeking relief and asylum and safety in Virginia, because this also has a negative impact on them in their cases. And so we strongly support this bill, and we would encourage everybody to vote for it.
Okay, thank you, ma'am.
There are no more speakers on Zoom, Mr. Chairman.
There are no more speakers. Senator Peterson, your name's still up here. You still want to speak?
No, I don't.
Okay. The committee operates by motion.
Move to report.
Motion and second to report. Are there other motions? Open the roll. A vote aye is a vote to report.
Ayes 8, no 6.
Okay, Senator Hashmi, congratulations. I think that's the first bill we've reported today.
Thank you.
Senator Hackworth.
Thank you.
You keep it on the roll, man.
Well, I want to thank Senator Hashmi for breaking that. I do have a amendment in the nature of a substitute.
Okay, your bill is 1073.
Yes, Mr. Chair.
Okay, this is a little bit different than before. But
Yes.
do I have a motion to adopt a substitute?
So moved.
A motion, do I have a second? I think that was a second I heard down there. All in favor of adopting the substitute, say aye.
Aye.
Any opposed? Okay, the substitute's properly before the committee. I think this is different because it says drop any item within the boundaries. That's on line 15. On 16 is obtain any videographic or still images of any identifiable inmate or resident. So this, I mean, the code already prevents the delivery of items to inmates. This is not, okay.
Yes, so, yeah, this is a little different. We had some concerns from the Unmanned Aircraft Association and also Wing, and they were just concerned because I think we had originally 400 feet, and they said that they could inadvertently, do that in delivering packages or whatever. So we worked with them, and they are supporting this. And the reason that we are doing this is I have several prisons in my district, and they are saying that they are having trouble with drones, sometimes even dropping contraband and things within 6 inches of open windows and things. So asked us to carry this to help that. And then also the other difference was they had a problem with the photo, so we had or obtaining a photo or video of an identifiable inmate or resident at any local or state correctional facility. So pretty straightforward, Mr. Chairman, members. We just want to make it in legislation that it is illegal to drop items over a correctional facility via drone, and prohibits drones from taking photos or videos of any identifiable incarcerated individual. And it would make it a Class 1 misdemeanor for the drone to do that.
I asked counsel, if this word identifiable, is that tight enough, you think? Identifiable inmate or resident? A still image of any identifiable inmate?
Mr. Chair, I think so.
Okay. Are there questions from the committee?
I got a question.
Senator Edwards.
Give me a real world example of what was actually happening. I mean, I tend to support the bill, but because people should be using drones to drop heroin or something like that into the correctional facilities. But give me an example of something that happened.
So, for example, like at the Keene Mountain facility, it's a large acreage, and in other facilities, Red Onion, different things, Wallens Ridge, they have trees that is close to the facility, and there's been instances where that drone operator within line of sight can be there and can drop that in a vacant part of the facility. And then, when the inmates are out in the grounds or things like that, it's been, they could pick those up. SIM cards is a big thing, drugs, just a number of things that can be done. So this just tightens that up to make that illegal.
Senator Edwards, you get your question. Senator Morse.
This is a follow-up on Senator Edwards. The question isn't what they drop.
Yes.
The focus on B, because I've got the substitute, is or obtain any videographic or still image of any identifiable inmate or resident of a facility.
Okay.
So we already understand, and you're going to probably have everybody with you, that it's probably not right. They're not dropping candy bars, Snickers. They're dropping contraband drugs or some other type of contraband. The focus is on the still image of an inmate. What are you trying to capture there, and what was the genesis of B beginning on line 15?
So the genesis of that, Mr. Chairman and Senator Morsi, was if for security purposes, and we have somebody that may have a little more authority that can speak on that. Go ahead, James.
Good afternoon, Mr. Chairman and members of the committee. I do have a specific example.
Tell us who you are.
James Toohey from the Department of Juvenile Justice. And we do have a specific example as to why that language is there. It was just this past year that we received information from a news organization that they wanted to fly a drone over our Bon Air Juvenile Correctional Center and capture video and photos for their website and for their news. And we at the Department of Juvenile Justice have a particular concern with regard to protecting the confidentiality of our juvenile residents at the facility. And so what we're concerned with is drones that have the ability or the capability of having high resolution, the ability to take high resolution photographs that would be close enough to identify a particular resident. So that's what gave rise to this, because the most that we could do when that incident happened was politely ask the news organization not to do it. And thankfully they agreed. But we didn't have any teeth to put into our request to say that pursuant to such and such statute, you have to make sure not to to obtain photos or videos of an identifiable individual.
Does that answer your question, Senator Morsi?
Yes, follow up.
Yeah, Senator Morsi.
I think, like I said, we're okay on line 15 with when you get to 3A. Do we have to have all of the language in B, obtain any videographic or still image of any identifiable inmate or resident of a state or local correctional facility? If the point is to stop capturing and not capture, not allow the capture of somebody who's in a juvenile facility, I think you'd have a greater appetite for the folks here. That's just my thought, as opposed to telling somebody that you can't fly over, Sussex 1 and capture, the image of the yard.
My understanding, Senator Morsi, from the Department of Corrections, is they have certain inmates as well whose confidentiality they have to protect. I think Department of Corrections is here.
1, 2, 3.
Good afternoon, Mr. Chairman. Rose Durbin from the Virginia Department of Corrections. To answer Senator Morsi's question, within the Department of Corrections, we do have individuals here who are assigned an administrative status, meaning sometimes they are here through interstate compact from other states. And those individuals we don't even identify on our website if you go to the offender lookup. And so the concern is if someone is looking out for them, if someone captures an image on a drone, then you know exactly where that individual is. And now there are other issues with the state where we're actually housing that individual for.
Can I ask one final question?
Senator Morsi.
So you really think there's a problem that an inmate at Sussex 1 may be there and somebody's flying over there and wants to capture that adult image to determine if he's there, as opposed to just going on the website and finding out where 26,000 inmates are? I'm trying to find what the problem is with this particular portion of the bill.
Sure, and Mr. Chairman, the issue is not so much the population, the larger population in and of itself. The issue is the inmates that we have here from other states that are on administrative location who are not identified through the offender lookup system, so you don't know that they're here based on the agreements that we have with those other states.
And there's been a complaint about that.
Mr. Chairman, we have received complaints and notifications from other states that individuals were actively seeking out the location of the individuals that we are housing for those states.
Thank you.
And are there other questions from the committee? If not, you've got a couple other people that have stood up. We can hear from the public now, or we can hear from advocates, or
Are there any Zoom participants who would like to speak on this bill? Please raise your hand electronically.
Okay, we've got some people in the room that want to speak.
Yeah. Good afternoon, Mr. Chairman, members of the committee. My name is Guy Rolling. I'm with Albers and Company. We represent Wing, which is a subsidiary of Alphabet. Wing operates the first FAA-approved commercial drone delivery system in the United States out of Christiansburg, Virginia. And we have had lengthy discussions with Senator Hackworth on this legislation. We're confident that the bill that's before you will not in any way adversely affect our operation in Virginia.
And so you've seen the substitute language?
Yes. Okay. Yeah.
Thank you. Okay, yes, ma'am. The Sheriff's Association has a position on this.
Yes, Elizabeth Hobbs with the Virginia Sheriff's Association, and we support this bill. Thank you.
Okay, thank you, ma'am. Are there people in the Zoom world?
There are no speakers on Zoom, Mr. Chairman.
Okay, there's been a motion to report and a second. Are there other motions? If not, open the roll. I'll vote aye as a vote to report. Senator Hackworth, I think you got the second bill for the day.
Yes.
Senator Deeds.
Oh, I apologize.
Ayes 15, no zero.
Evans here. I got to do him first. Senator Evans.
Thank you. Thank you, Mr. Chairman. I've got three bills. The first one is SB 1093, and there's a line amendment that I believe the clerk has to make a few minor changes, including a delayed enactment date. Should I explain them?
If you want to explain the amendment, then we'll take it up.
Sure. These all have to do with the procedures for notary publics. One is that an exam would be given to them within 30 days of when they apply for the license, or I should say a course would be given to them within 30 days of their application. And the other is that the provisions of the Act wouldn't become effective until January 1st, 2024, to give the Secretary of the Commonwealth some time to implement this at their request. And lastly, a deletion to recording a serial or identification number, which I don't believe was considered necessary to the larger bill.
Okay, do you understand the amendments? I'll take a motion to adopt the amendments. Is there a second?
Wake up, people. Let's go.
All in favor of the amendments, adopting the amendments, say aye. Aye. Okay, the amended bill is before you now. This bill, my understanding is that you introduced a broader bill last year that was carried over.
Yeah.
By a vote of 15-0.
Yeah.
Tell us about the differences with.
Well, the broader bill was based on this National Model Notary Act that came from the Association of Notary Publics. And the reason it was carried over was I asked the new Secretary of the Commonwealth for them to react, and they wanted time to review the bill more than just a session. So they had some time to look at it, and we talked about what we thought was necessary for notary publics in Virginia in terms of training and so forth. So the bill requires the Secretary of the Commonwealth to determine the appropriate type of training and examination. And many states require journals by notaries of their activities to record them. Virginia requires journals only for electronic notarizations. So there's really a lot of states require training. We'd be joining a huge number of states, including Utah, Missouri, Maine, Louisiana, North Carolina, Colorado, Montana, Florida, New York, California, et cetera. And their requirements range from taking a 6-hour training course to a lot less. And this would allow the Secretary to develop a training course and examination. And then notary journals are required in a lot of states. This would just require a journal of the notary acts in addition to any electronic notary acts. So we pared it down significantly from what was there last year after consulting with the Secretary of the Commonwealth's office.
Okay, are there questions for the patron?
I have a question.
Senator
Evan. This bill on, under, I guess, line 153, a notary should record in the journal the circumstance for not performing or completing any requested notarial act in circumstances of refusals. And so, why is that there? I don't understand.
I presume if someone asks you to notarize something that is suspect and that's not, that they want to have a record in case it should come up in court later or something, but I don't know particularly why where that piece came from. A lot of this language came from the National Notary Association and has been reviewed by the Secretary of the Commonwealth's office.
Well, I guess my concern is,
yeah,
if you're not going to do it, you can say, well, I'm not going to do it. But why should you have to record why you're not going to do it? I mean, they're not police officers.
Okay. Yeah, I don't know if anyone is in the room from the Secretary of the Commonwealth's office, but that's not the essential to this.
It might be relevant, for example, if a second notary does certified or something, it might be relevant in some legal dispute down the road.
Well, I mean, I guess what I'm saying is the first guy said, I'm not going to do it for whatever reason, and the second person does it. And the second person wouldn't necessarily know what happened to the first person anyway. I mean, I can see if, for purposes of policing something or prosecuting somebody, maybe it'd be useful, but just to require every notary, because some of them just, it's not an everyday thing. People at the bank, they'll do it for you. You know, my paralegal will do it if necessary, but it's not an every day or every week or every month thing. It's just on occasions. So I was wondering, is this overly broad? Is this, we're killing too many things that we don't necessarily need to kill?
Well, I think you probably do want lines 156 and 157 if you're correcting a previous completed notary action. but I don't know if there's someone from the Secretary of the Commonwealth's office in the room, but I'm not sure if that's essential on line 153 and 154.
Mr. Chairman,
Is there anybody from the Secretary of the Commonwealth here?
Mr.
Senator Edwards.
Yeah, several years ago, I carried several bills for the notaries, and we made a mistake on something, had to come back and correct it, the way it was done unintentionally. And so I guess I'm skeptical, why is this necessary? And should it be studied further by is there an organization of notaries in Virginia? I don't know.
There's a national organization, notaries, and a notary that's known to you, Craig Pfeiffer, had reviewed all this language and come up with it in the beginning from their national model policies. But like I say, that first little I, and second little I are not the essential part of the bill. The part of the bill we're getting at is to make sure that folks are trained, have had an exam, and that they keep a record of their acts. I could either have this bill amended, or we could pursue this as it goes through the process, and I could, let you know.
Putting it off for a week to let be looked at more carefully.
Then the bill will go back for the day without exception. You've got two more bills.
Okay, the next one is SB 1089 about eviction data collection. We've heard a lot in the news about Virginia being a state with a lot of evictions, but when we look more closely at it, we see that we're keeping records of writs of eviction, but we don't know if they've all been executed. So this bill would require that executed writs of eviction be returned to the issuing clerk by the sheriff who's executed the writ. And then there are two enactment clauses. One is that there'd be a report on the writs of eviction that were actually executed annually, and that the Housing Commission would convene a work group to study a more comprehensive data collection process to better track eviction data in Virginia.
Okay, does everybody understand the bill? Are there members' questions from the membership of the committee?
I guess I have a question.
Senator Edwards.
I'm wondering why.
Because
either you execute the writ or you don't.
Right now, we don't have data on whether writs of eviction have been evicted or if they were just merely issued and used as a.
Why does it necessarily have the record?
We want to deal with evictions and having the data to know whether or not people are truly being evicted, or if they just had a writ that was issued that was not executed, would be a better way to have that data.
Okay.
Mr. Chair, I hesitate.
Senator Peterson.
If someone doesn't pay rent and then there's an unlawful detainer action filed and the landlord takes possession and the person still hasn't left, and so they therefore go and get a writ, and the writ is then issued, but eventually it's not served because maybe at that point the person finally leaves.
Self-evicts or leaves,
Well,
yeah.
so they just leave. I mean,
Right.
At some point they got to leave. I mean, what's the data? What are we looking for here?
We're looking to get a better handle on how many people are actually being evicted in Virginia rather than just the writs that were issued.
I guess my point is, I've done a lot of landlord-tenant cases, and 98% of the time, the person voluntarily leaves before the sheriff shows up on the door and moves their stuff out to the sidewalk. Now, it doesn't mean they weren't evicted.
Right.
They were evicted. But I can only really remember one time where the person refused to leave, and he was still trying to refinance. He promised that, like, the refinance documents were coming in through a fax machine, and he was still standing by the fax machine, and all his furniture was getting moved to the curb. But I guess I don't see what the distinction is, Senator. I mean, I'm kind of like a writ of eviction. You know, there was an unlawful detainer action, an eviction action, whether or not it was served or not served. At the end of the day, what difference does it make?
The advocates working on eviction, I think Senator McClellan might have a comment.
So part of the issue is there are also cases where you may have the writ, but then the tenant pays, and you know, the landlord decides they're not going to move forward with the eviction at all. And in those cases, the tenant has not been evicted, But that still shows up in the eviction data because the eviction data is only looking at how many writs were issued. So I think what it would be trying to get at is when we look at what is called eviction data is really, there's been a writ issued and they're trying to drill down to see how many of these were a proceeding was initiated versus how many of these a proceeding was initiated and the tenant left, or how many of these were initiated and ultimately it was resolved and the tenant stayed, because it's difficult to craft public policy dealing with evictions unless you have precise data. That's what your bill is trying to get at.
I just don't think that, to me, it's not significant one way or the other. I mean, listen, once somebody's evicted, then you can turn around and rent it back from the next day, but they were still evicted.
They were issued a writ. If it worked, it could work out amicably. They could leave, or they could be forcibly evicted, and that's what we're trying to determine.
All right.
Okay, are there additional questions for the patron? Are there people in the are there those in the public who would like to speak?
If any Zoom participants would like to speak on this bill, please raise your hand electronically.
Please come up.
Good afternoon, Mr. Chairman, members of the committee. Tommy Herbert with the Virginia Apartment Management Association, as well on behalf of our sister organization, the Apartment and Office Building Association of Metropolitan Washington. I would say that Senator McClellan has accurately laid out the intents behind this bill. What we are measuring right now when we measure quote-unquote eviction data is generally eviction filings, which, as Senator Peterson correctly identified, are unlawful detainers, as well as judgments that are issued, which are often coming in the form of orders of possession. What we do not have is a centralized way to figure out how many writs are issued and how many of those writs are executed by the various sheriffs. We believe that there is a very large delta in that number that is worth exploring, and we would say that this would help us find out, again, where and how many folks are being evicted in the Commonwealth to help us make better eviction policy. It's something that we really do believe that no one is on the other side of that issue.
So you like the bill and you see it as a data collection bill?
Yes, sir.
Okay. Are there others in the public who would like to speak?
There are no speakers over Zoom, Mr. Chairman.
Okay, are there other questions for the members? If not, we operate by motion. Delegate Senator Peake's got a question.
For the gentleman that just spoke, I'm sorry, who do you represent?
The Virginia Apartment Management Association, sir.
So you are asking the Commonwealth to collect the data.
We are, yes, sir. There is not a feasible way to collect this data. It actually exists at the local level in clerks' offices. However, the idea of collecting it all on a statewide basis where it would be useful information, it would require an unrealistic amount of work.
Before he leaves, I have a question.
Senator Norman's got a question for you.
Following up on Senator Peake's question, where I appreciate your candor and knowledge, and the state is going to be your data collection, is your agency willing to reimburse the Commonwealth for the cost of our collecting that information?
We are very grateful to have worked with the Office of the Executive Secretary of the Supreme Court on this bill, and we are happy to report that there is no financial impact.
Senator Norman, is that your question? Any more questions? Okay.
This is recording the data.
The committee operates on motion. Motion to report in a second. Is there another motion? If not, open the roll. A vote yes is a vote to report.
Light green.
Okay. Senator Evan, you've got another bill.
Yes, my easiest bill of the day is on codifying.
I'm sorry.
Make sure we finish this up.
Oh, I'm sorry, yes.
Ayes 9, no 6.
Okay. My easy bill is on codifying same-sex marriage, which in Virginia, right now, we have...
You're talking about 1096.
Yeah, SB 1096. It just clarifies that marriage is lawful regardless of the sex of the persons in the marriage, two parties, and that religious organizations and members of the clergy acting in their religious capacity should have the right to refuse to perform any marriage. I would ask that we take a line amendment on line 13 to remove or gender and just say sex rather than both.
Okay. Do you understand the amendment? Is there anybody making that motion? Second. Okay, all in favor of that amendment, striking the words "or gender" on lines 13, say aye.
Aye.
Any opposed? Okay, that amendment's adopted. This bill simply restates the law, is that correct?
It clarifies that we're in compliance with Oberfell versus Hodges in that a marriage between two parties is lawful in Virginia regardless of the sex of the persons in the marriage.
Okay, does everybody understand the bill? Does anybody have any questions of Senator Evan? Okay, are there people in the those in the public who would like to be heard?
If any Zoom participants would like to speak, please raise your hand electronically now.
You can approach the podium.
Yes. Good afternoon, Chairman. My name is Narissa Rahman, Executive Director with Equality Virginia, and we are here in 100% support of Senate Bill 1096 and appreciate the Senator's longstanding fight to push this through.
Good afternoon. My name is Brianna Diaz. I'm Policy and Legislative Counsel for the ACLU of Virginia. We strongly support this bill and thank the Senator for its introduction and hope you all support it. Thank you.
Thank you. Thank you.
Good afternoon. I'm Elizabeth Fogarty from Arlington.
Bill Fogarty from Arlington.
And we're here as Unitarian Universalists and parents of two wonderful young adults, one of whom is gay. We support this bill so that both of our children will be able to live and thrive in Virginia and hopefully take care of us when we get old.
And believing in the inherent worth and dignity of all people, we think it is imperative that this bill be passed. Thank you.
Thank you. Thank you.
Chairman Josh Setzler with the Family Foundation. I'm here today to remind you of a basic truth. Marriage is a sacred and glorious institution ordained by God Himself as the first human institution. It is by its very nature the joining together of a man and a woman in a complementary and conjugal union. It is both a private and a public covenant and is uniquely designed for the benefit of the couple who enters into it and to society, and perhaps most of all, of the children who are born through its procreative capacity. The institution of marriage predates civil government, and therefore governments are obliged to recognize valid marriages. For all of these reasons, governments have a significant interest in honoring, promoting, and protecting marriage. And because a complementary male-female union is inherent in the very design of marriage, no one has the authority to redefine it, not even this committee. You can be certain that it will not and cannot go well for anyone who would attempt to defy God's design. On behalf of countless Virginians who acknowledge these truths, I implore you to consider them as you vote on this bill. Thank you.
Thank you, sir.
Mr. Chairman, members of the committee, Jeff Caruso with the Virginia Catholic Conference. I think you're all very familiar with the position of the Virginia Catholic Conference. I'll be extremely brief, but I just want to say that we continue to support the provision in Virginia's Constitution that was approved in 2006. And we know that that's a dormant provision right now because of the Obergefell decision. But nevertheless, in principle, we still support that provision. Thank you.
Okay, thank you, sir.
Whoa. Chair. Jeff?
Senator Morrissey.
Jeff, you and I are the same faith, and I think we even practice and attend the same churches, and we have similar thoughts on a lot of different matters. Tell me why we should, the Catholic Church, which is now welcoming more gay Virginians back into its church, at least in the dioceses of Virginia, why should the Catholic Church continue to support what many consider to be an outdated, archaic requirement? Why not just say, hey, these people love each other, get on with it. Let them do what they want to do.
Thank you for Senator Morrissey, Mr. Chairman. Thank you for the question.
Sure.
In the viewpoint of the Catholic Church, there's a unique benefit in our view, a unique benefit and public significance of the union of a man and a woman in a lifelong, exclusive, life-giving marriage. And so there's a unique benefit to that relationship that in our view exists in that relationship only. And for that reason, that's why we support this as a matter of public policy.
Okay, all right,
Mr.
thank you.
Chair.
Thank you. Senator Morsi, are you through? Senator McClellan.
You would agree that there are marriages that may not be recognized by one particular church, but can be and are recognized by the Commonwealth of Virginia, in addition to same-sex marriages?
Senator McClellan, Mr. Chairman, thank you. Yes, there is a distinction between a civil marriage and, a marriage that's recognized sacramentally. But we do nevertheless believe there's a public significance to a marriage of one man and one woman that's it's life-giving, it's exclusive, it's lifelong, and we think that relationship it should be elevated in our public policy as having a unique significance.
And I appreciate your view as a church, but the marriage code deals with the civil concept of marriage. And I would note that the Catholic Church did not believe that my parents' marriage, did not recognize my parents' marriage because my father was not Catholic and my mother was. And it wasn't until they renewed their vows in the Catholic Church 40 years later, after I was already born, that the Catholic Church recognized it. And yet I'm very glad that the Commonwealth of Virginia recognized that marriage.
Okay, thank you. Are there those in the Zoom room who wish to speak?
Yes, we have one speaker. Denise, you may unmute and speak now.
Thank you so much, members of the committee and Chairperson Deeds. My name is Denise Harrington, and I'm Director of Advocacy for the League of Women Voters of Virginia. The League of Women Voters of Virginia supports repealing the constitutional provision defining marriage as only a union between one man and one woman. And we support all marriages being treated equally under the law, regardless of the sex or gender of the parties to the marriage. The League also hopes the General Assembly will consider that the civil status of marriage is already clearly distinguished from the religious institution of marriage, and that religious rights will be preserved without additional language. And we thank you so much for allowing us to make comments. Thank you.
Thank you, ma'am. Okay, Senator, I think we all understand the bill. Senator Eben, if you want to wrap it up real quick.
Yeah, it's very simple. It just makes it clear that we don't discriminate in the issuance of marriage licenses. And we've had things that some of the opponents have brought up in past years. They thought that their organizations said, whether they thought it or not, they said that their organization should be forced to marry people. This makes it clear that any religious organization or member of clergy have the right to refuse to perform any marriage. And further, it limits marriage. It makes it clear that it's only between two persons.
Okay, thank you. The committee operates by motion.
I move to report.
Got a motion and a second to report. Are there other motions? If not, open the roll. A vote aye is vote to report.
McClellan? Hey,
Joe.
Joe, yeah.
Ayes 10, noes 4.
Ayes 10, noes 4. The bill is reported, and not only did you get two bills out of this committee, you've probably got half of our output of the day.
Well, I'm grateful.
We are now down to member bills, and we've got about 15 or 16 of them left, and I don't intend to stay here all evening to get them done. But Senator Peake's got a bill, he's got a bunch of witnesses here, and
Thank you, Mr. Chair.
what's the...
990.
Mr. Chairman, for planning purposes, should I consider that you were not going to do all 15 today?
We're not going to do all, we're going to stop around 5 o'clock or so.
All right, thank you.
And Mr. Chairman, thank you very much for moving us up. We have an amendment in the nature of a substitute. Is that what we've got? A substitute, yes. They're distributing that.
The Senate bill is 990.
Senate Bill 990, it's the penitent parishioner privilege bill, Your Honor. And we were here on Monday, and we've had a whole row of people who have been thoroughly involved in the crafting of this legislation. And the purpose of the bill is to point out that the priest penitent or parishioner penitent privilege lies with the penitent, clergy penitent privilege. And we've had extensive negotiations with members of the Catholic Conference who want to make sure that their priests still maintain their canonical obligations. And I believe that we have worked out this bill with the substitute that is agreeable with all parties.
Okay, the substitute's before you. I'd ask for a motion to adopt it. Okay, so there's motion and a second. All in favor of adopting the substitute, say aye.
Aye.
Okay.
And the privilege, and the phrase that we put in there that we worked out is similar. It's contained in other portions of the code, and I believe it is in compliance and approved by our Catholic Conference.
It requires the request or consent of the person who sought spiritual counsel or advice.
Mr. Chair.
And it can't be disclosed unless Senator Peterson's got something.
Yes.
Okay, I'm looking at a statute that was pretty simple, and we just seemed like we made it very complicated. And the simple version was, you could not force a practitioner you could not compel them to testify regarding a privileged communication between a pastor and penitent, i.e., if someone goes into a confessional and speaks to a priest and said, I did this, I did that, I did another thing, that priest could not be subpoenaed and then forced to say this person testified. So why are we making this complicated?
That was how the law always was. This is in the case where the penitent, the person who made the confession, wants the clergy member to be able to testify.
Okay.
And so the penitent is waiving that privilege.
They can do that anyway, Mark.
No, they can't. And that's why we have this bill. And that's why, so the clergy has maintained that they can't, even if the penitent waives the privilege.
Okay, can I?
Senator Peterson.
Notice the word that says shall be, no person, this is the original. The original language says no person shall be required to testify. In other words, the police can't subpoena them. That doesn't mean that a person can't come forward voluntarily. And let's say Suravel is in my church and he confesses to me and you know, I come forward and say, I want to testify. And Scott says, I'm not going to stop you. And there's nothing that prevents voluntary testimony. This just has to do with compulsion, which is a pretty key aspect of the law. So I just think we're needlessly complicating what should be a very simple statute.
Can I play the devil's advocate for a second? The bill right now or the law right now says no regular minister, priest, rabbi, et cetera, shall be required to give in testimony as a witness. Well, what if the consent arises, but the priest still says
doesn't want to testify.
I want to testify. Then the law says he can't be required to testify. Right.
But this clarifies that the law in almost every other state, the privilege lies with the penitent, which just like a client-lawyer privilege, the client can waive the attorney-client privilege. And that's what we're doing here. We're putting the privilege with the person who has made the statement, the penitent. But we're accepting.
All right, I just don't support this whole concept, so I'm
And where this comes up, Mr. Chair.
And it becomes
Mr. Chair. So where we've seen this come up is in cases when some of these clergy prosecutions for molesting children. And so the penitent will say, I told so-and-so that I was molested at this time, and I want the pastor to be able to testify. Well, the pastor might not want to testify. It might get his church in trouble. It might get his whole organization in trouble. So the pastor will not testify, saying, even though the penitent has waived the privilege, I can't do it.
Okay, Mr. Chair.
Senator Peterson.
So what you're going to say for the first time in Virginia history, in my opinion, is once a person goes to seek spiritual counsel from their pastor, that conversation may be compelled, they may be compelled to testify to that conversation. For the first time I've ever heard of this. We've never forced a pastor to testify to a confidential communication, period, full stop. Doesn't matter who wants it. And we're now opening that door.
Well, We're opening it for the person who made the confession to waive it, and where it comes in.
Well, then it's no longer confidential.
Well, it is still confidential. I went in to talk to my pastor. I made a confession to my pastor. I said, this other associate pastor molested me. And then a couple years later, I want to press charges against him. And then because of the change in the law, you can now testify about what you said at the time. I want my pastor to testify what I told him on that date. It is currently blocked by our current law. This would fix that.
Senator
Mr. Chairman.
Okay, so here's the problem. In many privileged conversations, there is one person to the two parties who wants to protect that privileged conversation. But it's unique with the priest penitent, Mark, because the privilege is the parishioner who goes forward and confesses. They've always had that. But you know what? The priest himself, when he is ordained, also promises certain things, to wit, I am not going to divulge a confession. What Senator Peterson is saying is we are now walking that back, and we are creating a slippery slope by saying, okay, even though the penitent now consents to coming forward, we're going to say that the priest has to testify when the priest took an oath when he was ordained, Mr. Chair, not to divulge under any circumstances a confession.
Mr. Chair, Senator Morrissey, that is exactly what we fixed in the substitute motion. If your canons require that substitute motion, and this was crafted with the Catholic Conference, the priest, because when they were ordained, they do not have to. And so the priests are exempt from being forced to testify. And that's why we didn't get to it on Monday, and what we have worked out, and why they're now here for 6 hours to try and pass this, which brings Virginia into compliance with almost every other state in saying that the privilege lies with the person, the penitent, not the clergy member or the church organization.
That's
just like attorney-client.
Stop right there. One final question. You just said it. The privilege lies with the penitent. What about the privilege of the priest who said he's not concerned about that particular issue? He doesn't want to ever be compelled to testify. I can't wait till Jeff Jeff comes up.
Mr. Chair, you didn't listen to me. They are exempt from having this. They are exempt under that. They do not have to testify. The priests are exempt. They are in favor of this bill. The priests are exempt from ever having to testify because that is part of their, when they're ordained in their canons. They are exempt. And if there's another religion that says it's part of their canons, they are exempt.
Mr. Chairman, I have a
Senator
question.
Edwards has-
I think lines 12, 13, 14 conflict with 35, 23, and 24. They totally conflict with each other. Here's the current concern I'm having, just like I had before you had this amendment. Let's say penitent A and friend B robbed a bank, and they conspired to rob the bank. And penitent A said, I'm going to testify now on behalf of the government, prosecution. Okay, and meanwhile, he goes and goes to his pastor, to his priest, and confesses. Say, I and my good friend, Mr. B, we conspired to rob a bank. And the prosecution wants him to testify, and they want corroboration for that. And they bring in the priest and say, you got to testify. What did he tell you? He said, he told me that he and his friend robbed the bank.
Well,
and that's the problem I have. It's violating the priest's
Mr. Chairman,
authority not to, in fact,
Mr. Chairman, Senator
not
Edwards,
to testify.
the priests are exempt. So let's get that straight. The priests are exempt. The priests do not have to testify under any circumstances because in this bill, the penitent cannot waive the priest privilege. That is what we spent a week straightening out. But B has no right to a privilege that A had. So if A and B go rob a bank and A goes and confesses to his clergyman, what right does B have to what A did with his
The
clergyman?
clergyman is honor bound not to reveal it in any event. That's the problem. And here.
Unless
No.
the person, and almost in every other state, Mr. Chairman, in every other state where the privilege lies with the penitent, just like attorney-client privilege lies with the client, and he can tell his attorney he waives it and wants him to testify.
Senator Peake, I see what you're trying to do, but let me ask you this on 23 and 24, doctrine of the religious organization or denomination. Are you setting a court up to get involved in doctrinal disputes? One group of Presbyterians thinks doctrine requires one thing, another group of Presbyterians disagrees violently?
Well, Mr. Chair.
And that has occurred in the Presbyterian Church.
Yeah. Mr. Chairman, and it may be that some statute we pass, not everybody agrees with, and a judge might have to make a ruling. So yes, if a judge had to make a ruling, he would say, clearly, the Catholics, under their doctrine, and when they are ordained, cannot reveal it. That is their church position. And then the judge might have to rule, because we'd have a motion in limine, Your Honor, you'd have a motion in limine. Well, the Presbyterians say, we can't
Hold on a
waive
second.
it either.
Do you know a precedent where courts have gotten involved in doctrinal disputes within a singular church?
Well, Mr. Chairman, this is an evidentiary issue.
Episcopal
that might-
Church over
it's-
property ownership.
Yeah,
that's
it is an attorney-client, it is a priest penitent, clergy penitent
Mr. Chairman,
privilege. There are some people here to
Mr.
speak
Chairman,
on it.
that's the other problem. It's an evidentiary thing. Let the courts work it out.
Well, right now, the way the statute, Mr. Chairman, they can't work it out because Virginia, unlike almost every other state in the Commonwealth, says the privilege lies with the clergy, not with the penitent. This statute would bring the Commonwealth into compliance with almost every other state in saying that the privilege lies with the penitent. Right now, under the law, the court doesn't have anything to work out because you can't waive the privilege.
Senator Morrissey's got a question.
Okay, Mark, I think
in the audience.
I want you to look at line 14. See where at the last two words, and this is what the statute used to say, no regular priest shall be required to give testimony. Okay?
Yes.
That's what it said. But now with the language it says, no regular priest shall be required to give testimony except at the request of the penitent. So there is a way and a mechanism now where a priest can be required to testify.
Well, they're Episcopal, Mr. Chair, they're Episcopal priests. The Catholic priest would not be required. There are other religions that call it
Oh, now you
priest.
really got it.
Yes, they're Episcopal priests as well.
If there are people in the room that would like to speak, if
I think we
somebody
got
in the
some.
Attorney General's
I got a
office.
whole.
If anyone on Zoom
got a
would like
whole
to speak
row
on this bill, please raise your hand electronically
Yes,
now.
ma'am.
Good afternoon, Chairman. My name is Nicole Whitman. I'm here on behalf of the Attorney General's office.
You're worried about what the priest might say.
Mr. Chair, the Attorney General's office, my name is Nicole Whitman, and we do support this bill. And I certainly understand, I am a practicing Catholic myself. I certainly understand Senator Morrissey's concerns, Senator Peterson's concerns, and the others, and they are valid. But that is why, exactly why, this is put in here about the fact that any communication or information that is required by the doctrine of the religious organization or denomination shall be kept in confidential manner and not be disclosed. We don't believe that this bill would force priests to break that covenant, to break that bit of that important facet of canonical law. They still would not be able to be forced or required to testify. What we're simply asking and what we're seeking through this bill is as follows, is unlike any other state in our nation, this right and this privilege belongs solely to the priest. What we're asking is to put the priest and the victim, oftentimes, of sexual assault cases when they are children, on equal footing, okay?
But you do agree with me that the lines 23 and 24 could potentially put a court in the position of having to decide between two groups within a church what church doctrine is.
Yes, sir, Mr. Chair, I do agree with that, and I think that that's a valid function of courts. Courts make those types of evidentiary determinations all the time. And I can tell you that this sprung from an investigation that was directed by Governor Northam to then Attorney General Herring, asking the Attorney General at that time, which this new Attorney General has also carried forward, to investigate these types of sexual abuse cases by priests. This is what we have found, is that this has been a roadblock to some of these victims of sexual abuse by clergy members from being able to at least ask that the priest or ask that the church in some capacity help them to disclose, help them to bring their cases forward and to corroborate the complaints that they had made. And if I may, I know I've exceeded my time, but in response to Senator Peake's question, and the way that we bring this forward in court, as those of you who are litigators certainly know, is through the recent complaint. That is a new statute, relatively new statute that was brought forward, where in cases of sexual assault, if a victim makes a complaint, let's say 10 years ago to their teacher, and in the trial of the person who committed the sexual assault, not the substance of what was said of the complaint that was made, but if, let's say, I'll say myself, I went to my mother when I was 7 years old and said, Mom, somebody did this to me. You know, now when I'm much older than 7 years old and there was a trial, then my mother could be brought in to corroborate that I did in fact make a complaint at that time.
Can I ask a question?
Yes, sir, of course.
Because you seem to always phrase it from the perspective that the victim needs to be protected.
Yes, sir.
But what about the person that's been accused? Let's say that the confession involved the person saying to the priest, you know what? It's all BS. I made it up. Now, can that statement be compelled?
If the penitent is the one who's confessing.
Because the penitent would say, no, I don't want you to, I'm not going to release that. I'm not going to waive my rights.
Well, if I'm understanding the question, sir, and Mr. Chair and Senator Peterson, are you saying that someone who is alleged to have committed an offense goes and confesses?
I'm saying that I'm trying to defend a client, and it turns out that accusant basically confessed that maybe it's fabricated.
I see.
And I'd like to subpoena that priest to testify, but now the penitent's like, no. In other words, this is a one-way street.
Exactly. And thank you for the question, Senator. And Senator Peake is correct. That's the current state of the law right now.
Exactly, but at least it's even. At least it's even. Now you just want to tilt it to one side.
I respectfully disagree, sir.
Well, I get to vote and you don't, so.
Yes, sir. that is, we can certainly agree on that, sir.
Okay.
Thank you.
Thank you, ma'am.
He does have a primary.
Are there others who would like to speak?
Mr. Chair and members of the committee, Jeff Caruso with the Virginia Catholic Conference. I want to thank the patron. I want to thank the Attorney General's office for the time they've spent with us and the attentiveness to our input. I also want to say that this bill was not our idea. This was not a bill that we brought forward. It was a bill that, in its original form, we were opposed to, and by working through it with the patron's office and the Attorney General's office, we came to a point where we're able to support it in its current form.
Senator Peterson wants to badger the witness.
You're not opposed to it because you've been carved out of it.
Exactly.
Well, I think
that's a yes or no, Jeff.
Well, I think what we're trying to do here
So
is.
the answer is yes, you have been carved out of
This
it.
is not a court, this is
Mr.
not a court
Chairman,
of
you
law.
need to control this committee.
This is not a court of law.
You need to control the committee.
Mr. Chair. Mr. Chair.
Senator Peterson,
Let him answer the question.
certainly.
and then-
Senator Peterson, Mr. Chairman, I thank you for the question. The way I would answer that is to point to the mandatory reporter section of the code, where clergy were added as mandated reporters in 2019. And when that was done, there was an exception made for situations where the doctrine of the religious organization or denomination requires the information to be kept in a confidential manner. So that's the exception that currently exists in the mandatory reporter law. So what we said we were willing to agree to is that make that same exception that already exists in the mandatory reporter law and make that same exception apply to civil and criminal proceedings and make things consistent throughout the code. And we said that we were willing to support that, and we do support that. At the same time, I mean, we're fine with the original law as well. And, this was not our idea, but at the same time, that this is something that we think makes sense on a matter of consistency.
Senator Morris.
All right, Jeff, we're going to dial it down just a bit. rather shocked by my friend's aggressive cross-examination. I've never seen that before. But he's correct. If you look at line 23 and 24, Senator Peterson is right. There is a carve-out for the Catholic Church because the priests in the Catholic Church, they take a vow and they never have to divulge a penitent's confession. What makes this bill more egregious is that now for one faith, certainly the Catholic Church, they get a benefit that others don't. Whereas before, it was a simple bill that no priest or rabbi can be compelled or required to give testimony. We are creating exceptions in this bill dependent upon what religious faith you have. We also creating an opportunity where somebody who doesn't have that religious organization or that doctrine of the religious organization, that they got to make a choice. And I got to tell you this, when a penitent confesses, he or she is not thinking, am I in the white chapel? You know, they're confessing and they think that nobody except for God is hearing that confession. This bill now says, not necessarily. You got to make sure that you're in the Catholic chapel, not an Episcopalian chapel. That's the problem. Okay.
But if I might add just one more thing, if there are any questions, particularly about the practices of our religious faith, I do have with us Father Tom Ferguson. He is the pastor of Good Shepherd Parish in Alexandria, and he's also a canon lawyer. Just if there are any questions of that nature. And with that, I thank you for your time.
I don't think there are any questions, but if you're compelled to speak, you certainly have the right to do that.
Once again, if anyone on Zoom would like to speak on this bill, please raise your hand electronically.
As Jeff said, I'm Father Tom Ferguson. I'm the pastor of Good Shepherd Church in the Mount Vernon section of Alexandria. And I've been a priest for almost 29 years and a canon lawyer. I only feel compelled to speak because I've been here for approximately 10 hours in this room, and I would hate to go home not having said anything. But I would reiterate, I think, the observation that's been made that the original language of this bill opened the door to a slippery slope. And the effort that was made here on our behalf through Jeff Caruso was really to draw the line where that slippery slope was going so that we would not be compelled, as Senator Morrissey has said, to be in a position where we would have to act in a way that was contrary to our conscience.
So, Father, you agree with my brethren that the slippery slope stops at the Catholic Church. Other clergy members may be compelled to speak.
I think the way the language of the substitution is written, it would include people of the Catholic faith, other Christians, rabbis, etc. I think that the practical example that we're looking at here, I don't know the practices of other religions, but I can give you the example of our confessional practice, the sacrament of penance, where that does have a direct impact on a Catholic priest who has a commitment in conscience never to reveal anything that has been shared in that sacramental form.
Okay,
Thanks. Thank you.
Yes, sir.
Yes, sir. Good afternoon, Mr. Chairman, members of the committee. Steve Rossi with the Family Foundation. We're in the same position as Jeff and the Catholic Conference. We saw the original bill. I approached Senator Peake, told him we didn't like it. Kind of yielded to Jeff to work out the language for something that could be agreeable. We can live with the language as is, but with the substitute. But we kind of like the status quo where it was. So, but I just want to say also, some of this is, as a Catholic myself, just to add something, a lot of this is moot. If you're like me, you go to confession in the confessional, the priest doesn't know who you are anyway, so I don't know where this comes into play where maybe Father knows, but that hasn't even been brought up. So a lot of it's moot as far as the penitent and the priest, so just for your consideration. And I also agree with you, Senator, about the having the courts trying to dig through doctrine. That was one of my concerns about the whole thing. Thank you.
Okay, is there anybody else? Is there anybody in the Zoom room?
There is no one on Zoom, Mr. Speaker.
Okay, do you want a minute or two to wrap it up?
No. No.
Okay, well, the committee operates on motions. Got a motion to report in a second.
Substitute motion to PBI.
Okay, substitute motion takes precedent. Open the roll. A vote green is a vote to PBI.
Ayes 9, no 6.
Okay, that was your bill for the day. Now, my understanding from Senator McDougal is that Senate Bill 902, he's got witnesses here. And what my plan is to take that up and then end for the day unless there are other people that have witnesses that have to be heard today.
Mr. Chairman, this is not going to involve a doctrinal dissertation at all. But, Mr. Chairman, 902, and thank you for taking it up. Witness had taken off to be able to be one physically here and one on Zoom. Mr. Chairman, you might have remembered last year came with a bill revolving around the authority of the Attorney General's office. This is a very small version of that and is focused in two areas. One are criminal sexual assault, so physical touching sexual assault, and then commercial sex trafficking.
Okay, this bill allows the Attorney General to prosecute
Correct.
cases locally in certain areas. It's like a bill you had last year, but a little bit broader.
No, the bill we had last year was broader. This is very narrow. Okay. It's only in two areas. It's only for sexual assault and commercial sex trafficking.
Okay.
Mr. Chairman, what typically happens, the Attorney General is finding frequently, they do have original jurisdiction to prosecute child pornography cases. And in investigation of child pornography cases, they find evidence of other matters during that investigation of actual physical sexual assault. And then they have to farm that out to a local commonwealth separate from the other investigation. So this would allow them to be able to do both of those cases together. The second piece of this, the commercial sex trafficking, as the committee is very familiar, individual organizations or individuals that are in a organized commercial sex trafficking are frequently across different jurisdictions. They're not located just in one area, and this would allow the Attorney General to be able to prosecute those. And, Mr. Chairman, I think there's witnesses here, and then the one witness is on Zoom.
Okay. Welcome. Witnesses, yes.
Cool.
Come on up.
Thank you. As I previously mentioned, I'm Justin Griffith. I'm the Commonwealth Attorney for Pulaski County. I'm here as a representative for my office and my office alone. As this gentleman mentioned, the Attorney General has original authority to prosecute child pornography cases right now as we speak. You're not going to hear from Commonwealth's attorney that they're stealing them, they're usurping them, they're going behind their back and doing that. That doesn't happen. Adding these two charges to the list that they have original jurisdiction on, I do believe increases the likelihood of justice being obtained for a child victim. If I'm, as the elected Commonwealth Attorney, if I meet with a victim and their family and I say I've reviewed the evidence, I don't believe there's enough evidence for a charge, and then the Attorney General's office comes behind me or with me and says, with all due respect to Mr. Griffith, we disagree. We do believe there's evidence. We do believe we can obtain a conviction. I'm going to be their biggest fan. I'm going to be the first one to shake their hand if they can find a path that I couldn't.
There's nothing in this bill that requires the local Commonwealth attorney to consent to the Attorney General's prosecution. You're all right with that?
I love it in the fact of the child pornography. We work well together. We've seen what they do. We see how that formula works. It works well. I would ask that we maximize the benefits of everyone's capability and that you guys support this bill.
Mr. Chair. Question. Can't you already get the assistance of the Attorney General's office?
Yes, sir.
Already, okay. And state police as well?
Yeah.
Yes, sir.
Already?
Yes, sir.
So this X's you out, and the AG has to do it, but your office can't get involved if...
I view it as it gives the victim another opportunity to have someone review it.
Well, I mean, right now, you can have the Attorney General assist you, right?
That's correct.
Isn't that better than saying, I can't do it, let the AG, he's got to do it?
If I say I don't see a path, I don't want to charge, I don't want to convict, I have no problem if a victim of a crime that's a child has another elected officials' office have the opportunity to review it. It's not about me.
But this would X any Commonwealth attorney out in this situation. The AG would have to do it because you couldn't.
But, or I could do it. I could choose to do it. But I'm saying if I don't see the path for the victim, it's a fallback option for the victim. Just the same thing in child pornography. It's the same way now. If I get a child pornography case that comes in and I'm like, I don't see it, I don't want to do it, I don't think it's justice, the AG can do it. But we work well together now, so we see how that works. We're not stealing these
My
cases.
question, though, is suppose you want to do it,
Yes, sir.
and you don't want the AG involved.
And that happens frequently in child pornography. We get together and we formulate who has the best resources, who can do it the
correct?
best.
In this case, the AG takes it over. You don't.
No, sir, we would work together, it's just like the child pornography now. So when we get one, I meet with Gene Fischel and we determine I have the resources or I don't. Here's the guideline range I think I can obtain. And then he'll say, well, I have more experience in this. And I may say, I would feel more comfortable in half of my county if you did this.
But again, my question is, you can get the AG's assistance already.
Yes.
Okay.
Senator Morrissey's got a question.
I'm sorry, I didn't get your full name.
It's Justin Griffith.
Mr. Griffith, you're aware that a similar iteration of this legislation came up last year?
I supported it last year.
Okay. The answer is yes?
Yes.
You're aware. And you're aware that the majority of the prosecutors from VACA said, no, we don't want the AG coming in and telling us we're going to take over a case that we don't want to prosecute. Are you aware of that?
Yes.
Okay. Third question, Mr. Chair.
Senator Morrissey.
You specifically said at the beginning of your colloquy that you're just speaking for yourself. Can I assume then that most of the Commonwealth's attorneys, members of VACA, are not in support of this bill?
You're going to hear from my friend, Mr. Bell, on that issue specifically.
What's the answer to my question?
I'm not going to discuss VACA. Mr. Bell's going to do that today.
So you don't know the position. Okay. Lastly, you're aware that the
Senator
Constitution... Thank you, Mr. Chair. The constitutional officers are elected by the people in Richmond or Pulaski or whatever.
Yes, sir.
And if they don't like the prosecutor's behavior or doings or the way he prosecutes cases, they have an option at the ballot box, right?
Yes, sir.
What's the option of the electorate in Pulaski County or Hanover County or Fairfax County if the AG steps in and takes over a prosecution? Is there any? Do they have any option against against the Attorney General?
I hope the option would be to support what the AG is doing to attempt to get justice. And then the Commonwealth of Virginia has the ability to vote for the AG every 4 years.
Let's hear from the next witness.
Yes, sir.
Thank you, Mr. Chair. Thank you for your patience.
If any participants on Zoom are speaking on this bill, please raise your hand now.
Yes, sir.
They're letting me jump line. I'm Michael Newman, Commonwealth Attorney, City of Danville. I'm actually here for VACA, and Senator Morrissey stole my thunder. We do oppose this bill.
Thank you very much. And Mr. Newman,
Yes.
it's your understanding that child pornography was added years ago?
It was added years ago, and quite candidly, we had this discussion. That was before some of us local.
Doesn't require consent of the local prosecutor, but what's been added since then has always required
Yes,
consent
that
of
is
the
correct.
local prosecutor.
That is correct. And as Senator Edwards pointed out, I could always ask now the Attorney General to help me on these cases.
Yes, ma'am.
Good evening, Chairman. My name again is Nicole Whitman. I'm with the Attorney General's office, and we are asking you to support this bill. I certainly understand the questions as they were asked, and I understand very well that VACA opposes this. But again, this is just our effort to support local prosecutors, to support local police, and to support local victims. We're looking for this authority that's already granted to us in a wide variety of crimes, including violation of laws relating to motor vehicles, including child pornography cases, in a very small number of instances that would deal with criminal sexual assault of children and commercial sex trafficking of children. Specifically, when it deals with the commercial sex trafficking with children, these are cases that often, and I'm sure those of us who deal in the criminal law world will agree that these types of offenses occur over multiple jurisdictions often. They move from Fairfax, I'm from Northern Virginia, they move from Loudoun to Fairfax to Arlington to Alexandria frequently and with ease. And someone who is a statewide prosecutor who has the authority to prosecute, and all jurisdictions in the Commonwealth is certainly better suited to be able to bring these types of cases. So we are not seeking to usurp the authority of the Commonwealth's attorneys. We understand that they are elected officials. We support them. But I would also say that, again, when we're dealing with the cases that we already have original jurisdiction in, child pornography cases, often it is the case, unfortunately, that when this evidence is reviewed in the child pornography cases, there appears to be children who are actually live children who are being touched. We'd like to prosecute those as well.
Thank you, ma'am.
One question, Mr. Chair.
Senator Morrissey, real quick question.
One question. You say you don't want to usurp the local Commonwealth attorney.
Yes, sir.
But isn't it true that if this law is passed and the AG says we're going to step in to prosecute under line 21 sexual assault, and the local prosecutor says, no, you're not, you could do it anyway?
Yes, Senator Morrissey, the same as we have the authority
I know.
currently.
All right, thanks.
Yes, sir. Thank you for the question.
Okay, we've got one more person standing up there.
Mr. Chairman, she tried to get in through the Zoom, apparently got kicked out, and I don't know that she can make it back in by the time we're trying to go, so she called in. She's not a native English speaker, so she has her interpreter.
Okay.
He came physically, and she was trying to come through.
Hello, my name is Ricardo Montoy with the Office of Attorney General. I'm going to interpret for a victim's mother here that would like to testify.
Okay.
Her name is Denise. Denise, ¿puedes ir? Yo hablo y usted déjame interpretarla, ¿ok? Hable unas cosas y yo interpreto.
Ok, muy buenas tardes.
Good evening.
Mi nombre es Denise García.
My name is Denise Garcia.
Soy la mamá de Ana Leticia García.
I am the mother. I'm going to omit the victim's name. No le voy a decir el nombre de la víctima, ¿ok?
Ok.
¿Qué más quiere decir? ¿Cómo fue afectada?
Ok. En estos momentos,
In this moment,
todavía muchos años han pasado ya.
it's been many years since this passed to my daughter.
El dolor
But the
sigue
pain is still present. It's many years since it occurred to my daughter, so the pain is still present.
porque lo que esperábamos realmente de la justicia
Because what we expected from justice,
no lo pudimos obtener.
we could not obtain that.
Nos sentimos prácticamente defraudados.
And we feel defrauded in this situation.
Quisiéramos que, así como al victimario,
We would like the way the victimizer,
hubiera algo que nos dijera que nuestro dolor va a durar 10 años.
just like the victimizer knows that he will be sentenced or he's in detention for how many years, we would like to have that assurance that, as he does, that we will forget about this and not affect us in 10 years, but we don't have that.
Y si nos portamos bien, pues nuestro dolor se va a cortar.
And if we behave well, then our pain is going to go away also.
Pero eso a nosotros como víctimas no nos va a suceder.
But us as victims and the family is never going to happen to us. Ya se acabó el tiempo. That was in the time.
Thank you. Well, was her case prosecuted by anybody? Was it?
I've met with her, Mr. Chairman, so I can't.
She's the mother of the victim.
And the victim, when this
It's
occurred,
Fairfax
when,
County.
where?
¿Dónde le pasó esto?
To Fairfax
In
County.
Fairfax County.
Set the case in front of Tom Mann.
So it was prosecuted by a local prosecutor, and they just got a bad result? No, it's not happy. Not happy
Yeah, no,
with
he-
what the
No,
judge did?
le están preguntando. Usted no. Le están preguntando. El delito fue condenado y usted no recibió los resultados que quería, ¿verdad?
Exacto.
That is correct.
Okay. Okay, thank you very much.
Muchas gracias.
Okay, are there others in the public? If not, the committee operates by motion.
Mr. Chairman,
Senator Surville.
we've been dealing with this issue now, I think, for 4 or 5 straight sessions, and every single time the Attorney General's office has asked for additional authority to prosecute, we have rejected that, and I would, under both Attorneys General, the prior one and this one, and I think we need to maintain that policy. I've moved to PBI the bill.
Is there a second to that motion? Are there additional motions? Okay, the substitute motion takes precedent. We'll open the roll. A green vote will be to report the bill.
It should, it just says Tom expired.
My apologies. The motion, if you don't mind.
The motion is to report. It's a substitute motion, so a motion to report.
It's also got to go to finance.
I apologize for that. If we report, it has to go to finance. Yeah, I thought that was just a technicality.
Technicality. Thank you.
Senator Deeds? Ayes 7, noes 8.
Okay, so we'll go back to the original motion, which is PBI. A green vote is a vote to PBI. All right.
Thank you, Mr. Chairman.
Ayes 8,
Thank you
no
for
7.
taking the time for the witness.
With that, thank you very much. With that.
Mr. Chair, very quickly.
Senator Peterson.
I had Senate Bill 845, which deals with immunity for statements at public hearings. I'd like to ask that that go to the Civil Law Subcommittee. It's going to need some work.
Okay.
That's mine. 845. It's called Home Cooking, Stanley.
Mr. Chair, I also have one.
Senator Peake.
I have 971. We're going to ask that that go with a letter. And that's what happened in the House, just a recommendation. We'll send a letter and ask them to study the magistrate issue.
The Executive Secretary's office?
Yes, that sounds good.
Okay, well,
PBI
motion to PBI, and then request the chairs to write a letter to the Executive Secretary. The clerk can send a letter.
Have the clerk send a letter.
Send a letter to the.
That's Senate Bill 971. Thank you.
Motion to PBI. Motion to PBI right here, second. Okay.
Ayes 12, no 0.
Okay, thank you very much. We left a bunch of bills on the docket, so we're going to be busy the rest of the year.